interest penalty is payable, I'm attaching, my lord. So, my lord, time already expired, my lord. Affidavit not filed. 10th January expired, my lord. I am praying, my lord, to take this matter, my lord. My stocks are damaging, my lord. 244 pieces Almira, my lord. Otherwise, my lord, I am challenging entire proceedings, my lord, here, my lord. I am praying to take up this matter, my lord, on urgent basis.
Very well. It will be listed. Listed, but it will not appear immediately as urgent motion because there are others. I'll run past till it little faster. Yes,
I'm praying, my lord.
Here, this is the second round. In the first round, the Congress bench had directed the executive engineer to keep 88 lakh rupees with them and ask the Adjudication Finance Department to determine my case. Now the Adjudication Secretary, it was regarding back to the executive. Transfer from back to the Adjudication Secretary passed an order. And that order we are telling because now the 88 lakh was kept as deposit. Now they are being the department, ESP department is asking Adjudication Minister to leave that. And in the last round, the Honorable Court has given liberty that whatever is the outcome of the Adjudication Secretary's order, that is further, I can come before this court. And I don't want that money also because they have issued under 74 for back to GST conversion and state has not paid. I am not asking for tax. But today the liability is only of interest. That's why I click from myself. So if I can get the reader of interest on the ground of 128 law, then there is nothing left. I'm a contractor or 88 lakh is written. Give it to me, I shall see.
Last talk.
Last week, I kept today for the delivery order 74, which has gone to 56. Which one? So we have 56 cart infra. Very well, I think I will reach today. Let us see.
My lord, may I permit? My lord, last occasion I mentioned the matter for order correction. My lord, direction is given that have notice opposite and I have the notice yesterday, my lord.
For correction?
Yes, my lord. Only the order writ petition ER correction.
Yes.
My lord.
Extension please. Extension please.
My lordship, PL number 762. There has been delay in filing the income tax return for which the condonation of delay has been filed under section 19(2)(b) of the Income Tax Act. However, it has been rejected on ground of reasonable cause, and that due to which we have not received the refund of tax amounting to 16 lakhs. Since the company is very small and causing a financial distress, I would like to pray before yourselves to take up the matter a little early.
It's there in the list.
Yes, at 762.
762. Very well, you give it, you shall see. Don't come and mention tomorrow that it has not been upgraded.
My lordship.
Please give me some time because there are already a lot of urgent matters which have been upgraded. All the matters will go in that list. The ordinary list will be empty. I don't want that situation. Yes, Mr. President.
I am given to understand that that file was listed before this honorable court but has been transferred to Siliguri.
Yes.
What has happened is I have challenged the show cause notice. Show cause notice has been issued.
If it is before it pertains to the Jalpaiguri determination, it has to be there. It can't be here.
The show cause notice has made me answerable to Jalpaiguri officer, but I have proposed to invoke certiorari against the show cause notice and the officer to bring the records out. Those records, exist in Kolkata Karaya Road. That's why, I am pressing it before appellate side in this honorable court as opposed to Siliguri, because though the show cause notice makes me answerable to him.
May I have your lordship please to mention a matter? May I have your lordship please to mention a matter? My lord, item number 1017 of your lordship please, monthly list. My lord, a matter Siemens Limited. But this matter pertains to an eviction of unauthorized occupant tax. This is a writ petition file challenging the order of the DM. So this matter is appearing under the heading hearing your lordship, and your lordship hears the hearing matter on Wednesday. However, this unauthorized occupant tax matter
1017 the unauthorized occupant hearing it is.
And my lord, some precedence may be given because this matter
This is on Thursday. It will be taken up on Thursday.
Gratefully, Lord.
1017 का ये कर दी. Unauthorized occupant hearing. Yes.
Petitioner received a notice from the respondent authorities for the recovery of demand, and petitioner filed the restitution report here for the limitation of rejected an appeal petition, and petitioner filed the appeal within 91 days. 90 days is statutory limit, and bond is delayed. That's why for the bond is the respondent authority reject the application.
Give it. Okay.
I'm on behalf of the respondent. Tax
Well, I
authority.
think we will reach today. I'll
My lord,
go
I
a
am-
little differently.
I'm-
Please wait, sir. We may reach today.
Yes.
Good. Welcome.
This is coming up as to be mentioned for the reason, my lord, there is an extreme urgency in the matter. We are challenging, my lord,
Who is appearing for the?
my lord, I tell you, lordship, we have challenged the validity of the regulations of rules, tobacco rules, and we have also challenged three notifications. Now, my lord, I believe, my lord, Mr. Kundoli is appearing for the Union of India, which is mainly the answering respondent would be the Union of India. I think Mr. Sharma would be assisting Mr. Kundolia. And my lord, we have also served upon the commissioner, the jurisdictional commissioner. The matter is extremely urgent, my lord, immediate subject to your lordship, present your lordship.
CGST, nobody is representing CGST.
We have served. But my lord, the answering respondent at this stage would be, my lord, the Union of India. I tell you, lordship, because, my lord, the precipitative action is yet to be taken. We are not challenging any action of the commissioner. We are challenging the regulator. So, lordship kindly take only one paragraph. Your lordship will find the scope of challenge. The scope of challenge, your lordship will find at para 3. These are the, my lord, the rules made under, my lord, section 3A of the Central Excise Act.
Can you take instructions in this, because CGST also is required, although
We have served. There is a service. ये क्या original है? ये कौन सा additional service है? मतलब after moving also we have again served. मतलब we have the affidavit service ready.
It has been written as respondent number 3 not with south. So the assembly has to make the concerned commissioner by which he is assessed.
मतलब it is the south. The
So
south.
south has to be served. So what
South has been served. South has been served.
But I shall.
Well, I tell you, lordship, with every passing day, my lord, we may be visited with both civil and penal consequences.
Mr. Banerjee, when can we have it?
And this is very urgent, my lord. I will request Mr. Banerjee and Mr. Kundolia, Mr. Sharma is here. So, my lord, we have served upon all the parties, my lord. Let us move the matter. Talk to the here.
Let me take instructions from.
When tell me a date, accordingly to because no, whenever you say, because you will have to take instructions.
I can show the. Yes, sir. South इसको बोलता था south
Level service.
Five, service has been effected 5 days ago, both by hand and by mail at post. So it's 7 days now. We have effected service.
The party
So by the time we will be able to move the petition, by the time we will visit with an order also and a focus also.
because not south is commission. So that's the reason nobody knows.
Yes, actually, he's right, Mr.
Not south.
The nomenclature of the
We may delete not straight away now. We have effected service on south.
because if the cost title is like this, nobody would own up.
Malad, we will just delete not. We have effected service on south. Right, Malad, we have already. Because south is our jurisdictional commissioner.
So you should have made south only. Why did you write north south?
Malad, we will delete, Malad. We will delete.
I'm giving you leave to correct the cost title.
We will correct the cost
and,
title right
Mr.
now.
Banerjee went to a fix it.
They have received the copy, man. They should be ready in the matter. If they don't want to move the matter, that's a different thing. And I
One
tell
of
you,
them
your
will tell
lordship,
you when you want.
the jurisdictional commissioner right now is not the answer in this point. Because he cannot defend the rule.
He may have something to say, Mr.
Yes,
He
yes.
may have something
But my
to
lord,
say in
kindly give
support
us
of.
a date, my lord, so that my lord,
You tell me, you all tell me a date because he wants it now. Now it will not be possible because you don't have instruction. So you
but
tell me a
tomorrow,
date
my
which is
lord,
feasible.
tomorrow,
Day after tomorrow.
day after tomorrow, very well. My lord, need to correct the cost title right now.
As prayed for by Mr.
Item number 2, my lord, I am appearing virtually, my lord. My lord, in this case, my lord, I must be candid before your lordship. There was a direction for filing affidavit in reply, my lord, since it was received by only on 17th December, my lord. It could not be filed, my lord, due to my lord some my personal difficulty, my lord. Kindly allow me 2 weeks time, my lord. I will. My lord,
One full.
I am unable to hear. I am unable to hear you, lord.
Yes, Mr. Dugar.
My lord, in this case, your lordship has given the direction for filing affidavit in reply, my lord. My lord, I could not file, my lord, the affidavit in reply in the meantime, my lord. I am paying 2 weeks time, my lord, to file the affidavit in reply, my lord. Because, my lord, the petitioner's bank account has been declared NPA, my lord, and petitioner is running after, my lord, bank, my lord, for to get the, my lord, this NPA account, my lord, restored. Well, kindly allow me 2 weeks time.
The interim order is already there till the end of February. So why did you mention it for extension now? It's already there.
Well,
Next week you could have made it ready, the affidavit in reply by
yes,
the time. Because
it will
what will I
two
extend
two
now? It
weeks.
is already, we have just reached halfway mark somehow. It is there till
Yes,
28th of 27th of February. Why are you
yes, madam.
mentioning
My
it now? In
junior.
the meantime, get your affidavit in reply ready, because last occasion
Well,
also
I
it
need
was not ready.
to. No, my lord, last occasion, my lord, they have served me on the last occasion only affidavit in opposition, my lord. 17th, my lord, December.
17th December also, we are 2 months now.
Yes, yes, yeah. I'm not, my lord, taking it. My lord. Kindly allow me
Because
2 weeks time,
interim
my lord.
order
I
is
will
being
file.
extended unnecessarily. We could have then finished of this matter. What is this matter about?
My lord, my lord, my claim of input tax credit was disallowed on the ground that the seller's registration was cancelled ab initio, my lord. And my lord, I am covered by this honorable court's judgment, my lord, in the case of the LGW Sanchita Kundu, as well as, my lord, other courts, my lord, judgment also.
But we are not at fault. We have filed our opposition.
Yes, yes. Mr. Dugar, learned advocate appearing for the petitioner, submits that the petitioner needs a little more time to file the affidavit in reply. Full stop. Let affidavit in reply to the affidavit in opposition filed on behalf of the state, comma, be filed within 2 weeks from date. Full stop.
Grateful, my lord.
List this matter for hearing in the combined monthly list of March 2026. The interim order passed earlier shall continue till the end of March 2026.
I will file, my lord. I am grateful, my lord.
Next.
My lord, in this matter, this writ petition has been filed challenging the notice under section 148. Now, I am praying for extension of interim order because there is an approved matter before the Supreme Court, and this is to be heard within 17th February. So, my lord, kindly extend the interim order. Lordship, Mr. Bhattacharya is appearing in this matter. Your Lordship, I'm praying for an extension of time to file our opposition.
This matter is appearing under the heading extension of interim. Yes, opposition, Mr. Chakravarti.
Can you don't record anything? Whenever the matter is getting. It fixes this matter in the month of March, when is the
No,
minor.
but extension, if I am not granting, then it will be difficult for you to file. ওই সেম অর্ডার করে দিন, আগেরটাই করে দিন, শুধু মিস্টার চক্রবর্তী যে ভট্টাচার্যের জায়গায় মিস্টার চক্রবর্তী হবে। Clearly. Next. Yeah, same matter. Lordship same.
ওই সেম অর্ডার করে দিন, নামটা চেঞ্জ হয়ে মিস্টার কুন্ডালিয়া হয়ে যাবে। আচ্ছা, মিস্টার কুন্ডালিয়া and Mr. Chakraborty pray for extension of time to file affidavit in opposition. আগের নামটা মিস্টার ভট্টাচার্য ছিল, সেখানে হয়ে যাবে মিস্টার কুন্ডালিয়া and Mr. Chakraborty. Wait for time, extension of time to file affidavit in opposition. দেখিনি আগের অর্ডারটা দেখছেন তো? প্রত্যেকবার একই জিনিস বললে সময় যাবে না, কি এটা
Grateful,
করে
grateful, my lord.
বুঝেছেন তো? হ্যাঁ,
But I've got the recall please cancel. By registration cancel on the ground for non-filing return and will be fixed now. I prefer an appeal discuss on the ground of limit. Now today, though I challenge the order of the appellate court that is I also paid your loss the last of the sentence. Then initial clear. Let my refund be revoked upon payment of all taxes, interest, and the payment of any. Over here. I have seen this judgment, I have seen more two stuff. Upon cancellation of my release, I have two ways. Either I have prepared an appeal, or I can file an application under section 30 for revocation of my registration. I prepared appeal. My appeal dismissed. I took this submission to the degree lawyer and few questions in detail. If I file my appeal and my appeal is dismissed, does it barred me for seeking revocation? But my appeal dismissed. I'm not going into the merit of my claims. Whatever the allegation against me, if I seem to be section 5, sir. You may talk.
difficult. No, here in this case, he has lost before the appellate forum. Does that mean, Mr. Banerjee, that for all times to come he will not be able to do business for the purpose of restoration of registration?
Well, restoration of registration on the ground of delay. Well, it has merged with the order of the appellate authority.
Right. Now the order of appellate authority also can be challenged before the writ court on the ground of on merit.
On merit.
Now suppose he is willing to put in the penalty, late fees, cure all the defects.
Well,
In that case, whether the appellate authority's order will still stand?
because the authority's order. Well, kindly, your lordship will kindly see that it is appearing at page 29 of your lordship brief.
Page 29.
Starting.
Right, he does not have power to condone delay. That's absolutely correct. There is no quarrel with this. But then suppose he approaches the authority and says that what is the provision for restoration? Where is the provision for restoration?
30. Revocation of cancellation of registration. Section 30.
Here also there is a provision for appeal. I mean, limitation is there. I'm seeing that. Plus 180 days. Actually, in this case, he has preferred an appeal in the meantime. And in that case, there was no appeal preferred. That is the problem.
Ultimately, the generation of revenue to the government. I can run my business, government can get the revenue.
When was your appeal preferred?
But my appeal was preferred on 4th November 2024.
4th November
20,
2024.
20, 20, yeah, 20. An order of the appellate authority of 28th of March 2020.
Well, the order in original was passed on 14 March 2023 and
So-
we filed the
So this was within the time within which revocation application could have been filed within the condonable, because 6 months and 3 months,
9 months.
so 9 months. Why did you prefer appeal? You ought to have gone before the.
practically remand the matter to the original authority, otherwise name run.
Yes, that is better. Since the appeal was filed within the time within which the adjudicating authority would be.
The rules have 20. Yes, but I no. I cannot.
I'm treating this as an application for revocation and taking cue from the earlier orders where it has been passed, because unnecessarily it will create difficulty. And what will we gain? That will be loss of revenue, isn't it? Because if it was on other grounds like fraud or something, then
No. Only on the ground of
only on the ground of non-filing.
non-filing of non-filing.
You have the division bench judgment where,
No, but we don't have. Concord.
yes, I would have taken support of that.
But
लिखे नहीं. This. 8 নম্বর কি হয়েছে? এটা কোর্টের আগে করিয়ে নেবেন, এগুলো কেন? এটা ঠিক নয়, লিস্টে যখন মামলা থাকবে। Yes, nine.
With respect to item number 8,
It is passed over. File is not.
Lordship, I was seeking a passover as well. Lordship, list of courses.
Your Lordship, just why not I just hand over the Bihar judgment which I got, why not I'll.
Yes, item 9.
Your Lordship, actually, I apologize, my lord, for interjection, my lord, actually, in one matter, item number 69, your Lordship had on the previous occasion, my lord had granted a stay till today, and my lord, instead of fixing, my lord had indicated that if both the sides are here, at 11 o'clock, my lord would be pleased to take it up, and that matter is being led by Mr. Ratnanko Banerjee.
No, this is that matter, my lord, where we are arguing about the family settlement. my lord.
Mr. Lahiri was appearing on the
And
other
Mr.
side.
Sharma, my lord.
Mr. Sharma was led by Mr. Lahiri on the last
My
file.
lord.
Yes, Mr. Sharma, when can we take this up? We can take it up today at any time.
Lord, 11টায় বলেছিল।
Well,
Very well, we'll be
whenever all of
we'll
you
be
are
here
here,
at 12 then, my lord, we'll be here. তাহলে 12টায় করুন একটা।
We won't have time, my lord, to finish. That's the problem, my lord.
you come at 12,
12.
maybe 12, 12, 5.
I'm sorry, my lord, we are
Actually,
Grateful, your Lordship.
9 o'clock.
Your Lordship, as for item number 9, Your Lordship, in this writ petition, we have challenged the penalty order. It arises from the assessment order which was passed on 20th of March 2025 for the assessment year 23-24. And that assessment order was a subject matter of challenge in writ petition being 8698 of 2025, which writ petition was disposed of by Your Lordship on 10th of February, whereby
the
the
order.
assessment order was set aside in abject violation
Then,
of principles of natural justice.
Consequential, it has to go. Decided. লিখে নিন। This a arise from the assessment order dated March 20, 2025, which has been set aside by this court by an order dated February 10, 2026, passed in WPA 8698 of 2025, therefore, the impugned penalty order and the impugned demand notice can no longer continue upon the basic order being set aside. Full stop. Paragraph. In such view of the matter, the impugned penalty order and demand notice, both dated September 29, 2025, in respect of assessment year 2023-24, stands set aside. Full stop. It is clarified that the respondent revenue authority shall remain free to initiate appropriate proceedings in accordance with law if any further assessment order is passed in respect of the same assessment.
I'm so grateful, Your Lordship.
In respect of the same assessment year. WPA 24618 of 2025 stands disposed of, no costs.
I'm grateful, Your Lordship.
Next.
But in this matter, I'm appearing for the petitioner. My lord, in this matter, what happened, my lord, it was a cooperative society where there was a change in PAN. My lord, after change of PAN, they had continuously started filing their returns from 15-16 in the new PAN. In 17-18, there was a 143-2 assessment where the assessee or the petitioner informed the department saying that, see, I have changed my PAN from 15-16. Those all the cash deposits that
You have copied your instructions.
No, my lord, we have twice we have informed the department, my lord, they have not given any instruction regarding this matter.
Why?
My lord, we have wrote an email, my lord.
Where is Mr. Dutt?
Mr. Dutt, my lord, is
Please call him. I'm passing it over.
Okay.
Yes.
10, 12, and 13.
10, 12, 13.
10, 12, and 13. Please call him.
We are challenging either the show cause notice for the period 2019-20 to 23-24. Only before issuance of show cause notice, they have issued the DRC-01A, the intimation, on 25th of September 2025. Well, they have asked me to give the reply on 29th of September 2025. In the meantime, on 26th of September, we have filed a reply asking for the adjournment, and we have submitted some of the some clarifications required. Well, in the meantime, on 27th September 2025, they issued the show cause notice in form of show cause notice along with the DRC-01, without giving me any opportunity to file another reply, the proper reply to the show cause notice. They have issued the DRC-01. Second point is,
No, but show cause notice has been issued to you.
before pre-show cause notice, that is an intimation, DRC-01A. Before issuance of show cause notice, they have to issue the DRC-01A. They have issued DRC-01A on 25th of September 2025. Asked me to file a reply on 29th September 2025. We have filed reply on 26th of September. Asked me to kindly give us some details of the. We cannot file the reply without the material facts, and we are asked for the time of 3 to 4 days to file the reply. They have, in the meantime, on 26th of September, they have issued the DRC-01, the show cause notice, impugned show cause notice. Kindly just may I place the kindly come to page 141. DRC-01A, 25th of September 2025.
141A.
141, 141, my lord. Annexure P12.
Yes, 141.
That is, my lord, kindly see the right side of the 25th of September 2025. The show
Yes.
cause issued. Asked me to file a reply on, my lord, kindly come to page 145, first line.
145.
145.
Yes.
In case you wish to file any submission against the above ascertainment, the
The
same may be furnished by,
29/9.
yes, my lord. Then, my lord, we have filed on 26th of September 2025, my lord, for adjournment petition, my lord. My lord, may I read from paragraph 2, my lord? The notice would like to state that although the DRC form DRC01A has been uploaded on the GST portal, the same merely contains the demand has been proposed on account of alleged non-payment of GST on TDR and on availment of ITC on construction of immovable property. However, neither the basis of forming such allegation nor the provision under which such alleged violation have been committed by the noticee have been provided along with the intimation. Further, no breakup of the year-wise amount attributable to the ITC related discrepancies or TDR related discrepancy has been provided. The entire demand has been classified under HASN 995414, the pertaining to the construction services. In the above background, the notice is unable to understand the particulars of the demand proposed and how the facts pertaining to the notice result in such alleged violation. In this, the noticee would like to state that it is impossible for the noticee to furnish any reply to the said intimation in the absence of necessary information, and the intimation only provides 1 day to file a response, as the entire state of West Bengal, including the offices of the noticee and the legal counsel thereof, are closing from the evening of 26 September 2025 on account of Durga Puja festival. The said timeline provided by the intimation to file a response for a substantial amount of demand is against the principle of natural justice. Accordingly, your good office is requested to kindly provide us the details of the allegation containing how such allegation correlate with the facts pertaining to the notice's activities, post which the notice shall be able to form a constructive reply in 4 to 5 days, 5 working days. Then will kindly come to next page, page 148, that is DRC01. The period is April 2019 to March 2024, the tax period.
Yes.
Then will kindly come to that signature, digital signature, page number 152, 152, my lord. Validity of digitally signed by Bhim Ratna Rawat, dated 27th September 2025. Then will kindly come to page 153, the show cause notice dated 27th September 2025. Then will kindly come to last page of the show cause notice. That is, my lord, kindly come to page 173. That is 27th September 2025.
Yes, madam.
Your Lordship, they had issued the DRC01A on 26th. On 27th, they have already filed on 25th, they have issued. On 26th, they have made the reply. If your Lordship may come to page number 172, in paragraph number 8.1, after considering the reply, they have issued the DRC01. Your Lordship, if they have any problem, if they have anything to say, then they can reply to the show cause itself. But instead, they are coming to the court on the ground that DRC01A is not valid because there has been less time given. Even though 5 or 6 days has been given to the assessee to file their reply, they have filed their reply. Thereafter, DRC01 has been issued. Your Lordship, they have given the reply. Thereafter, it has been the DRC01 is issued. It is not that before they have filed any reply, the DRC01
But
is
in any
issued.
case, Mr. Mojumdar, if show cause has been given, you can still file show cause. If
The
they find
yes.
merit in your reply, they will not proceed.
No, they have to proceed, my lord. If the show cause notice is issued,
If,
they
if,
cannot.
if after the if in your reply to the
It
show
is a
cause,
condition precedent for before issuance of show cause notice, the pre-show cause consultation. My lord,
that is May. It was shall earlier. It is now May.
May, my lord,
It
they
can
have
be issued. It
when
cannot
they have
be issued.
when they have issued, my lord, kindly you have to give them some time. Reasonable time has to be given. 25th September they have issued, we have filed a reply on 26th September, they have issued the show cause notice on 27th. They can give me 2 days or another 3 days.
On that ground, show cause notice will not be bad, Mr. Mojumdar. Why can show cause notice? Because if they can do it, let us see it this way, Mr. Mojumdar. They can issue a show cause notice directly even without issuing a pre-show cause. That is within their authority. Merely because they have issued it and they have not considered it at this stage of show cause, they will consider
It's
it.
like 148A proceeding. Before 148, if they have to issue 148AB, we have to file a reply, they have to pass the 148AD. Then 148 notice can be issued. Then the proceeding start. If they pre-check, they have to, this is a basically they have to check whether they have to issue the notice or not, show cause notice or not on a particular case. But in that case, they have not provided any opportunity of hearing personally, any hearing. We have asked for the time. They can they can also issue on 26th September after receiving my letter. They can ask me, we have to file a reply by 1 day. They can easily say. And one more thing, they have issued the consolidated.
Once you have asked for his reply, he has given reply to the notice to show cause.
Your lordship,
Why
that
would
is
you
not
not
an
consider-
adjournment, your lordship. And my learned friend is telling that it's an adjournment, but your lordship.
Sort of that, it is sort of that only. If you read the reply, in the reply he has said that we have not been able to understand anything. Please provide me something. Then he has not dealt with that. You should have said that no, nothing more is required to be provided.
Page 147 specifically says, we have asked for 4 to 5 working days time to file reply.
You have, if they have sought for an adjournment, maybe that you would not have proceeded further.
But your lordship, as in we know that according to rule 142 1A, it is not mandatory. And the amount in DRC 01 and DRC 01A is the same. So where is the prejudice your lordship caused? Your lordship thing remains the same. Even though it is not mandatory, they have issued DRC 01A. After that, they have filed a reply. It has been considered, though it has not been considered according to the assessee, the way assessee wants, but it has been considered. But where is the prejudice your lordship caused here? Because the amount in DRC 01 and DRC 01A is the same. And although it is not mandatory, they have issued a DRC 01A.
They have intimation issued for the period of 5 years. They have asked me to 1 day time to file the reply, and also without providing me any details of the proceeding. They have to give me the details of the and my lord knows that we are challenging the show cause notice also. They have issued the punching of show cause notice. My lord are already hearing this matter, my lord, in other 2 matters in case of Dhansari.
Mr. Mojumdar, prima facie, I am not satisfied that any hearing or, any adjudication is supposed to be done prior to the show cause. Because because rule 142 1A, it shows that they will only communicate to you the details. That's about
time and again the court has said that
communicate.
Why they have issued this notice intimation. Why have asked me to file a reply on 29th of September 2023? I am asking the question to myself. Then why we have filed a reply? They have to consider my reply and whether they can reject my prayer. Or they can give us a personal hearing also.
That will be extending the scope, because then
No, they have
every
issued the court.
moment hearing will be required.
No,
It is only for the purpose of
opportunity file reply. Well,
it
it is
is
some
only-
futile
it is-
exercise.
it
Why
is-
they have issued my? I'm asking the question to myself. Why they have issued DRC 01?
Your Lordship, the
They
process
have issued
starts
to
from
communicate.
show
That
cause.
is the section. It says communication,
The
nothing more than
communication
that.
cannot be empty formality.
It
it
appears
cannot-
to be that.
it-
If
it
it is
cannot-
may, if it is may, Mr. Mojumdar, it appears to be that.
No,
It is not shall. It was shall.
It was-
Legislature thought of it. It did away with shall, incorporated may. There has to be some sense of
Then, my lord,
meaning imputed to
then,
it
my
when
lord,
the
why they have
legislature
asked?
itself does away with shall and replaces it with may. You have to give some importance to it. It is not that it was all through may. It was all through shall. Subsequently, it has been done may. There
My
has
lord-
to be some intention
My lord,
behind
I'm
that.
grateful to my lord observation. I'm saying, my lord, if it is what the today, my lord, I cannot go beyond the statute. My lord, if they issue the show cause notice, ask me to file a reply on 29 September. We have filed it 26 September. Why they have issued the 27 September to the show cause notice? Why they on 27 they have issued the
They
show cause
issued
notice?
only to communicate that this is the tax payable by you. You can pay.
My lord, it is
That
a-
is the only intention
the
there.
pre-consultation, well, it is required. Right now, there is a thought it should be amended. Well, they have issued the show cause notice. They have to abide by that. When
Show
I
cause
file a
notice, you are
reply,
getting an opportunity to show cause notice. You are getting an opportunity
well,
to
in the
say whatever
yes,
you say.
well, then also, well, they have issued the show cause notice issued for the 5 years, for the period of 5 years. They have to issue the show cause notice separately. My lord had other three high courts already held that they cannot issue the show cause notice. Constitutional
Now,
show cause
there
notice
are
cannot be issued.
equal authorities. There are other authorities also which have held in section 74. It is possible. It can be done.
No, my lord has, I think here, my lord has not been passed any order.
No, I have not passed any order, but it is
Well,
not sanguine that it cannot be done. There is equal weight of authority on both sides.
And each assessment is different from the others.
That
They have
can
to issue
always
the differently,
decide
and
that.
different segregation has to be there. How the assessee could file the or R3 RTP could file the reply.
Very
So
well.
one more opportunity can be given. I am asking for one more opportunity to file my reply before issuance of show cause notice. They
At this stage, I don't want to set aside the show cause notice only on that ground. I can give you an additional opportunity to file a reply which will be considered along with your reply to the notice to show cause. That can be done because it otherwise, or what else? Because show cause now has been issued. I will have to set aside the show cause. That ground, only on that ground, setting aside the show cause, at least prima facie, till now I am not satisfied. That is not a very
kindly
strong ground
appreciate the
for-
if even assuming if the statute doesn't provide giving me the opportunity of hearing, if I ask for
show
that,
cause notice itself, Mr.
I'm saying all that is show cause is not required to be issued as at all in DRC 01 is not required to be. If the authority concerned issued the show cause notice, asked me to file a reply. I have filed a reply, asked me to kindly give
That
the
is not
details.
a show cause notice. That is just a
Well,
communication.
well,
It is not
communication
show cause.
also.
Yes.
Communication.
Why are we treating
But
then it is
communication,
not
well, kindly.
the statute, Mr. Mojumdar, does not contemplate two show cause notices.
Well, if
This is
the
something which is alien to the concept of adjudication. You will get only one chance to file your reply. You can improve upon the reply that you have already filed, but that does not mean that every time then the proceeding will never be able to proceed
Then will
further.
kindly come to page 145. Well, kindly see that same may be furnished on 29 September 2025. They are asking me to file a reply.
But the reply has been filed, Your Lordship, already.
No, this is not cannot be reply. I've asked for the time for 3-4 days, and clarification is required. I could not file my proper reply. Well, kindly see page 145.
Your Lordship, here
Well,
proper
kindly
it's not
the same may be furnished on 29 September 2025 in part B of this form.
Your Lordship, if your Lordship may come to page number 172, paragraph number 8.1. The reply from the taxpayer was received against DRC 01A.
It is on record. It is
Part
on
A,
record that it
in
is not
part
going to
B
be a
of
file
the
reply.
of the
It
respective
cannot be
form
said.
on 26/9/2025 RUD 15. In their reply, the taxpayer submitted that the DRC 01A merely contains the demand proposed on account of alleged non-payment of GST on TDR and availment of ITC on construction of immovable property, but neither the basis for forming such allegation nor the provisions.
Kindly see the once again, may I read?
I've read it, Mr. Mojumdar, on that ground, it becomes difficult.
Then why the part B is there? Part B is why it is there part B. If the statute provides or the machinery provides, the rules provides, the part B is there. They have to file a reply.
We will not extend it to such an extent that it becomes a first show cause, second show cause. It should not be that. If at the earlier point of time it was shall, yes, it was there. But and they have dealt with it in a manner.
Why they have driven? I have asked for the time to file a reply. I could not file my reply.
That I have explained in 8.2, saying that
why they have issued 27.
Even if we had filed a reply, they were well within their rights to issue a notice to show cause. They could have issued a notice to show cause even then. And you still have opportunity. There is no prejudice to it.
If the show cause notice, the adjudication start. If the then 148 notice cannot be challenged. If the
148 notice could have been challenged.
This is also
148
also these show cause notice can be treated as 148 notice, my lord. If this is a jurisdiction show cause notice.
That logic we cannot import every time, Mr. Mojumdar.
Why I am saying, my lord, why I am saying
something which legislature has not done, by extension of logic we cannot import that into statute. That is not the way we interpret.
Doesn't provide any opportunity of hearing. Then, my lord, only the second submission, my lord, is there. They have issued the show cause, the improved show cause notice for the period of 3, 4, 5 periods. They cannot issue the bunching of show cause. It is not possible.
Bunching, very well. You make your submissions on bunching, and till such time that you will participate in the proceedings, they will, if they pass the final orders, they will abide by the result of the writ petition. They will not give effect to the final orders. That is all that I can do. You will have to participate, because in bunching, that notice, that matter also have passed the same order.
Fast one, what will be a fast one? My lord is saying that it is possible they can issue the notice and we.
Yes, prima facie, I am of that view. That is why, I am not going to stay the notice on that ground. That ground I am not satisfied, because it says
opportunity. One more opportunity can be given.
I cannot set aside the notice, Mr. Mojumdar, on that small ground. That ground is not convincing enough. I have to be convinced. You have seen me. If I am convinced, you don't have to speak a word. If I am not convinced, even hours of argument will not make me convinced till I am convinced. It has to go into my head. It is not going into my head. That for that reason, because the statute says communicate the details that they have done and may. So even without it, if they have power to do it, suppose they had not issued that DRC1 at all, DRC 01A at all, they had directly issued the notice to show cause, could you have challenged? You would not have challenged.
I could not have challenged.
Then merely because they have gone a step ahead and they have done that, that does not make it justiciable. In my limited understanding of the law, I'll put it on paper if required. But at the moment, interim order, by way of interim order, I can do only that, since bunching is also a point which has been, argued by you. Therefore, I can say that you participate in the proceedings. Final order will not be given effect to till such time that the proceedings are there. That is all I can do. Or if you can argue it out immediately, you can argue. How much time is there for the adjudication proceedings? They give you some time, isn't it?
They have issued the show cause personal hearing. They have the time.
You have time. So let us argue that then. The bunching thing.
Then kindly fix the matter next week. Bunching or show cause, I will.
Yeah, both points. I am not deciding any point. Not only bunching. You argue that point also. I have opened my mind so that you can answer. I have not made up my mind.
Yes.
But I am talkative so that people can understand what is crossing through my mind.
Your Lordship, my
it's a privilege. It is our privilege to know.
DRC 01A was not mandated.
That I have also understood.
Then why are we coming here to challenge that which is not mandatory?
No, he has a bunching point is also.
Lordship, in Ambika Traders, your lordship, it
I've
is
seen
already.
that. I've seen that. It is under consideration because we don't have any Calcutta High Court judgment.
Your lordship.
So none of them is binding on me.
Your lordship.
I have to be bound by either of them or Likun. Heard Mr. Mojumdar, learned advocate, appearing for the petitioner. Yes, next. কিসের পাস হবে না পাস হবে না এখন ওই ইয়ের হ্যাঁ Yes, Mr. Dotto, why are they not getting instructions?
10, 12, 13.
8 তো পাসড ওভার হয়ে গেছে ছেড়ে দিন হ্যাঁ
10, 12 or 13.
Why are they not giving instructions? Mr.
This is one matter, Millard, your lordship, Millard, remember that we used to face some difficult department at times who don't understand what we tell them, who don't give proper instructions, and they give their own logics, which I cannot say in the court. So, Millard, I would request your lordship, Millard, kindly allow me to file an affidavit in these matters and kindly stay the proceedings.
My lord, one humble submission. There is a judgment of Gujarat High Court on a similar fact where the.
I have to see their version.
Let me I place the judgment.
What is the impugned order that you are challenging?
My lord, the 147 order.
Huh?
Millard, here initially, Millard, he had taken a pan, Millard, on the basis of a trust.
And the officer concerned, let him come then. This is not
Millard,
the way.
he is aware of your lordship, Millard, and he has in the past instructed your lordship also. Well, I shall give his number, Millard, or name.
Not required. Name is not required. Let him come and explain why instructions are not being granted.
Page
Millard,
72.
he doesn't understand anything. Even by written instructions, we have asked for it by mailing, Millard, through CID judicial also, but
লিখুন তো Mr. Dutt, please wait. 12 were filed in, 13 are filed. ঠিক আছে 13 same order in 12 also.
Yes. 12 and 30. Fileটা দিন
Ah, 13 is same order. I just check if directions were there in the earlier order. Next.
Just praying for a not today, Lordships.
Not today. Chalo. What is this matter? Delay?
Lordships, delay, but this is additional portal in the old portal, not the new portal.
So next.
Tomorrow.
My lord, I am for the petition. Here is your affidavit of service. Affidavit of service.
Income tax এর বইটা দাও। এই যে বইটা এখানে যায় না এই বইটা।
Yes.
My lord, we are a cooperative society. We have farmer members. We take money from them and give interest against that, meaning we have banking transactions. So whatever interest we earn from deposits and the interest we give against deposits from farmers, this is our income. My lord, the petitioner has got registration under the Societies Act, Bengal Societies Act, since 1955. So this is a very old society. The petitioner has all along been using a pen ending in B, filing ITO and doing other meaning observations under the Income Tax Act. In January 27, under the wrong advice of their earlier chartered accountant, they procured another pen. The new pen was never used in filing return or otherwise. My lord, for financial year 17-18 and assessment year 18-19 also, we have filed the return, and the return was assessed also. After 5 years, more than 5 years of the assessment done, the respondent number 1 issued a notice under section 145 AB, 148 AB, which we replied. Thereafter, he issued a notice under section 148 and an order under section 148 AD, reasoning that as you have 2 pens, so they are separate entities. They did not consider our replies that we have only 1 set of books of accounts, 1 return, 1 audited accounts, and 1 registration under the Societies Act. So, and the new pen number was never used by us. That is the our return for 2018 is my lord, please see it on page number 23. It, 23 is the acknowledgement of the return. We submitted this return with our old, used and regular pen, and 24 onwards, page number 24 onwards. is the assessment order under section 143(1) of the Act. My lord, the
old pen,
two pens that we refer to. The old pen is at page number 32. This we always used. We are using it in filing returns. And the extra unused additional pen, which we are ready to surrender, and we have sought permission from the jurisdictional authority so that we can surrender. He has asked us not to surrender right now. It is at page number 34. The impugned notices and orders. Page number 36, my lord. This is the first notice. We replied to it, saying and reiterating that we are only one individual identity, one identity, not two separate identities. From bank accounts, audited balance sheet, and final account statements, everything was given to the authority. But they continued saying that you are two separate entities simply because you have used the full name in the second pen, which is at page number 34, Krishnanagar Samobai Krishi Unnayan Samiti Limited. This is the full name of the organization, and the full name is there in the old pen also, but the popular name is used in the card, PAN card. Krishnanagar SKUS Limited. SKUS stands for Samobai Krishi Unnayan Samiti. But I repeat, my lord, that the second PAN was wrongfully procured, sought for, with the ill advice or wrong advice of the then chartered accountant of the company, but it was never used by us in filing return or otherwise. The principle, my lord, that for one set of accounts, one organization cannot be assessed twice without finding any incriminating documents. Should I continue?
Yes, please. Please complete.
In page number 37, they said that amount of 1 crore 66 lakh 18,558, this has been deposited by the organization in West Bengal State Cooperative Bank Limited. We replied that yes, this is our deposit, but this deposit does not constitute any income because these deposits are from our customers. As we are in the banking transactions, so we get money, we deposit, and whatever interest we have to give to against the deposits, etc.
Here, the taking of the second pen, a person cannot hold two pens. Taking of the second pen, your lordship will see that in the second pen, he was given notice under 148 AB. He did not reply to it.
Then a 148 AD order was passed. It did not take in steps.
We
Then
replied,
140
my lord. Oh, we replied. I said to you, my lord, that we replied to
No, he has
the
replied.
notice.
The reply has been considered at
Yes.
page 40, if you
Yes.
see. Page 40, paragraph 5.
We replied that
He said the PAN does not belong.
Why is the name different? It is.
it is the same name, my lord.
It is not the same name. SKUS Limited and Unnayan Shramiki.
Yes,
Unnayan
Unnayan
Shramiti Limited. You cannot make a short form of a company like that. Limited company. It has to be in accordance with the name which is incorporated. How can you change the name suddenly? You cannot make a short form on your own.
No.
Only short form which is permitted is for private and limited. No other short form.
But it is issued by the income tax authority.
Because you have sought for it.
Yes.
Why did you sought for? Why did you seek for this?
In the appointment, my lord, at the very first, your petition, my lord, page number 2, paragraph 1. Your petitioner, Krishnanagar Samobai Krishi Unnayan Samiti Limited, popularly known in short as Krishnanagar SKUS Limited, is a primary agricultural credit cooperative society.
Your statement will not do. What is there? What is other document? Is there any other document to show
Yes,
that
yes, my
SKUS
lord.
and you are the same entity?
Yes, my lord.
What is that document?
Please see page number 23 once again, my lord.
23.
Page 23.
Page 23.
Yes.
Is the income tax. It is the acknowledgement. The full name is written over there against the same pen. Pen number is quadruple AK 8533B. This is the old pen number. Krishnanagar Samobai Krishi Unnayan Samiti Limited. This is the full name of the organization. And you see the next page, my lord. This is the assessment order.
Yes, Mr. Dotto. This clarifies things because
it clarifies, but then he has to surrender one PAN.
Yes,
he will do. But if he has already been assessed under one PAN, how can he be doubly assessed?
That can be sorted out, but first he has to surrender the first PAN or the second PAN.
Yes, my lord. As I said earlier, that we approached the jurisdictional assessing authority.
Mr. Dotto, come back.
272, section 272 says that upon payment of a fine of 10,000 rupees, they can surrender the PAN, but they are not willing to surrender.
Yes,
and why has the earlier return filed by him not been taken into consideration? There is a return filed by him in respect of the same assessment year for which you have reopened the proceedings.
Because
this is assessment year 18-19.
It is in respect of a different PAN.
PAN will not change the entity. PAN is only the account number. Entity remains the same. It is in the name of the same person. Krishnanagar Samobai Krishi Unnayan Samiti. That is the same entity.
Whatever transaction was there in the first PAN, it was also taken.
So that
into
ought to have been
consideration
checked. That ought to have been checked by the assessing officer whether the transactions are same or not.
My lord, we have presented here in the pleadings that we have 9 accounts, including this account which is included in the second PAN. So in the our statement also, and in the no. And
come back with the instructions.
Okay.
This petition assails an order Come back in 5 minutes. আগে চলুন, এগিয়ে চলুন।
Wait, please, Your Lordship.
Not affidavit of service. Not affidavit of service. Yes, sir.
Yes.
What
is
in
this matter?
application, we have challenged
এটা কিসে? মানে এলো?
for defreezing the bank account, whereby a proceeding under section 132 was initiated in the year 2018.
Proceeding under?
132 of GST Act was initiated in the year 2018. Subsequently, Your Lordship, several bank accounts were frozen by the investigating agency. And thereafter, Your Lordship will kindly come to page number 39. Everything will be clear, Your Lordship. Bank accounts were frozen. And with regards to that, the other companies have approached before this honorable court. And thereafter, by virtue of the order, the bank accounts were defreezed. And today, on the basis of that order, we are approaching before this honorable court. Your Lordship will kindly come to page number 39, which is very clear. Yes, Your Lordship. Lordship, order dated 9th of
Who is
February.
appearing for the respondents? No, CGST authorities will be required to be represented.
My lord, but the Lordship will kindly come to page number 39. And in the order, it is specifically mentioned that earlier, Union of India was appearing.
How have you served the CGST authorities? CGST you haven't served.
My lord,
You have not served the CGST. They are the main respondents.
I'm coming to that, Lordship.
লিখুন। Service on the respondent numbers একটা ফ্লো চলছে যখন চলবে, মাঝখান থেকে আপনি ব্রেক করে দিলে আমার অসুবিধা নেই, কিছু বলতে হবে না। Yes.
Your Lordship, in this matter, Your Lordship, though appeal could not be filed within 3 months, Your Lordship, the appeal was filed within further 1 month condonable period, Your Lordship.
Filed within the condonable period.
Lordship.
Then that can be done. Who is there? Mr. Chakravarti, you are not there here. It's not. It is for state only, isn't it?
Lordship.
Within the condonable period, we could have done away with this. No, but you are appearing or not? You are not appearing then. Nobody is appearing. You can appear, Mr. Chakravarti, in this. You can take instructions. I'll record. Affidavit of service. Yes.
Can it be cooperative?
Not.
Lordship's item number 8 is still passed over, so we can start with that whenever Mr. Bose is
8, who is appearing?
For us, Mr. Bose is leading the matter.
He's not there. It is for them to start. Mr. Bose is still not there.
Yes, Mr. Bose is there. I'm
Very
waiting
well.
for that
Moment
matter.
will not চলুন চলুন আগে ইয়ে চলুন পরেরটা চলুন না 15 19 তো Yes.
Your Lordship, I beg to appear virtually in serial number 19, Your Lordship.
Yes.
Your Lordship, the short issue involved, I'm challenging the order passed by respondent number 2, which has said that I am not an exporter of services and I'm an intermediary. Now, Your Lordship, I'll just brief you on the transaction per se in only 30 seconds. Your Lordship, I'm an educational service provider. And Your Lordship, what I'm doing is, if someone wants to get into, for say, Oxford or Coventry University in the UK university has appointed me in India.
Item 19 চলছে
19, Your Lordship.
Yes.
Yes, Your Lordship. Now, Your Lordship, the UK university has appointed me in India so that any student who needs counseling can come to me and I will provide those counseling services and guidance to
What
those.
is the order impugned, sir? What is the order impugned?
It's the order in additional, Your Lordship. It's P1, page number
Why
41.
did you not prefer appeal against the order in original?
Your Lordship, two reasons. The first and foremost reason is, Your Lordship, this is covered by the judgments of various high courts as well as the Supreme Court, Your Lordship. So what they have done is judicial indiscipline. And not,
Yes.
Your Lordship, I have a judgment from the... I beg your pardon, Your Lordship.
Yes.
Your Lordship, that is the first round, that there are at least 7 judgments of different high court. Everything has been confirmed by the Supreme Court, saying that educational service providers like me are not really intermediaries. They are exporter of services, Your Lordship.
Who is appearing for the state GST authorities? Yes, Mr. Sanyal. State is the answering respondent.
Your
এর আগের অর্ডারটাই পাস করে দিন none appears. Where is your affidavit of service?
My lord, just
দাঁড়ান দেখি
Your Lordship, the respondent is Union. R1 is Union of India, Your Lordship.
No, whose order are you challenging?
Assistant Commissioner, Your Lordship.
Where is that?
Your Lordship, page 41. My apologies, Your Lordship.
It appears to be an order passed by the state authority.
My apologies, Your Lordship.
Yes, so state is the answering respondent.
Yes,
not
Your
the
Lordship.
union.
Yes, Your Lordship.
Then service also doesn't appear to be complete. 12/12/25 delivered. Assistant Commissioner Revenue. Serve notice at the GP office. Service is not complete. লিখুন service on the state GST authorities is not conclusive. Full stop. The petitioner shall serve a copy of the writ petition along with a fresh notice on the state GST authorities, intimating them that the matter shall be taken up next on March 9, 2026. Full stop. A copy of the writ petition along with a notice shall also be served on the office of the learned government leader, intimating him about the next date. Full stop. List this matter on March 9, 2026.
Grateful, Your Lordship.
Next.
May I please, Your Lordship, I beg to appear through VC in item number 20.
Lordship, the affidavit of service.
Who is for the income tax authority?
Service has been effected, Your Lordship.
Lordship, this is a challenge to reassessment proceedings for assessment year 18-19. There are 5 grounds of challenge, Your Lordship.
No, serve a copy on the Commissioner Judicial. They won't be able to appear like this. Here you have to serve a copy on the Commissioner Judicial. What is your ground of challenge here?
Please, Your Lordship. Your Lordship, there are 5 grounds of challenge. Lordship, apart from 151A, which is being considered, Milords, on the same transaction which has been initiated, for which the reopening has been initiated, the same subject matter transaction proceedings were also initiated against 6 other sister concerns. And there, after considering the reply, in all the cases, the 148 AD order was passed, accepting the transaction and dropping the reassessment proceedings. So therefore, once the same subject transaction stands accepted in the hands of sister concern based on same very information, the reassessment initiated against me on the same transaction, Your Lordship, is without jurisdiction and these orders cannot coexist. My learned friend will hand over a chart, Your Lordship.
Lordship.
If Your Lordship will just have this chart for a moment. I have placed the order passed in the case of sister concern in this writ petition itself, which I also furnished before the assessing officer, that based on this very information, this information is fallacious. You cannot initiate based on this wrong information. He says nothing doing, I will still initiate. He doesn't deal with this specific ground. Because, Your Lordship, the information proceeds on the premise that upon a spot verification being carried out, the assessee was not found to be existent. Now, later on, it emerged, Your Lordship, that the spot verification was carried out at an old address which used to be the premises in 2018. Thereafter, the premises were changed, and this fact was considered in all the other cases, and all the assessing officers dropped the reassessment proceedings because this information was found to be wrong. So based on this very information, a contrary view is being taken against me. This is first ground of challenge, Your Lordship. Second ground of challenge, Your Lordship, is on limitation. This proceedings has been initiated beyond the period of 3 years for which certain jurisdictional conditions are required to be satisfied. A, that the amount of alleged escapement has to be more than 50 lakhs, and B, that the escapement is to be represented in the form of asset. Subsequently, the law was amended in 2022 to also cover cases of escapement represented in the form of expenditure or in the form of entry. Now, Lordship, this issue again is being considered by several courts as to whether that amendment will apply to assessment year 18-19 or not. So this is the second ground of challenge, Your Lordship, that where the allegation is made that the alleged escapement is in the form
Very
of...
well, you serve the Commissioner Judicial and come back.
Please, Your Lordship, My only difficulty is, Lordship, show cause notice has been issued with due date for 19th
Can't
of
be helped.
February.
You should have served it in the proper way. You should have got appropriate instructions from your learned advocates practicing here. Likhun. The petitioner shall serve a copy of the writ petition along with notice on the office of the Commissioner of Income Tax Judicial, comma, full stop. Now, along with a notice intimating him that the matter shall be taken up next on March 9.
Your Lordship, may I request for February? I'll be grateful, Your Lordship.
February may be difficult. We only have 1 week in February.
I'll take my chances, Your Lordship. I'll be grateful for this indulgence.
Very well. February 25.
I'm so grateful. I'm so grateful, Your Lordship.
Affidavit of service to that effect shall be filed on the returnable date. February 25. Same heading.
I'm so obliged, Your Lordship.
Grateful.
He has come to court. Okay. No, if he has not come to court, then you give your name.
My senior is virtually available.
My lord, I am appearing for the item number 21 and 22. Both are similar matter, my lord. Here, what happens, my lord? In 21, refund has been given for the period for quarter ending 31/3/2009, amounting rupees 44,34,120 in November 9, 2022. We have given two representation, April 25, April 28, 2025, and August 4, 2025.
Page.
These two representation has not been considered.
Sir, which page?
This page is 27 to 29.
Page 27.
No, ma'am. I'll have a look into the page. First representation is
page 27 are challans.
Just,
Oh, it has shown again.
Page 23 is the first.
Page 23.
I'll have a look into page 25.
Page 23 is a form, revised notice.
First representation is at Milord, page 25.
The brief which has been served to me, my lord, is page 23. Go ahead.
Page 25 is a representation.
25 is a representation.
25 is a representation,
is not there.
23rd April or 28th April? What is the date?
23rd April.
And thereafter another representation, my lord, on
Is August.
August 4, 2025.
Page?
There are
my page is 27.
I have looked at page number 31.
Page 31.
Yes, ma'am.
Page 31, what is the date?
No, the check into page number.
4th August 2025, ma'am.
4th August. लिखे नहीं
my humble prayer is to consider the representation.
Yes, I'm doing that only. This writ petition has been filed alleging inaction on the part of the respondent. Which respondent? Respondent. Respondent number 2.
Respondent number 2, my lord. I'm just 1 minute.
Page 31 is absolutely blank. I mean the addressee. Who is the appropriate authority?
My lord, the additional commissioner, my lord, because he is the authority in the circle.
Respondent number 3, my lord.
The first representation is addressed only to respondent number 2.
Yes, ma'am.
The second representation copy has been forwarded.
And it's
Very good.
second represent copy all copy given to all.
Alleging inaction on the part of the respondents in considering the petitioner's representation for payment of interest.
Interest on
Payment
refund,
of
ma'am.
interest.
For payment of interest on refund. Payment of interest on refund under the
Right.
Central Sales Tax Act,
Yes, ma'am.
1956 for the year 2014-15. Full stop. Paragraph. Learned advocate appearing for the petitioner invites the attention of this court to representations dated April 23, 2025 within brackets annexure P3 at page 25 of the writ petition bracket closed, and representation dated August 4, 2025
Yes, ma'am.
within brackets annexure P4 at page 31 and 32 of the writ petition, annexure P4 at pages 31 to 33 of the writ petition. Bracket closed, and submits that despite the aforesaid representations being made to the respondents, the respondents have not made any payment on account of interest on refund to the petitioner. Full stop. It is submitted that the fate of the petitioner's requests stroke representations has also not been made known to the petitioner. Full stop. Paragraph. Having heard the learned counsel appearing for the respective parties and having considered the material on record, this court is of the view that no purpose would be served by keeping this writ petition pending. Full stop. Accordingly, this writ petition is disposed of by directing the respondent number 3, i.e. the additional commissioner, 24 Parganas Circle North, to consider and dispose of the petitioner's representations at pages 25 and 31 to 33 of the writ petition within a period of 4 weeks from the date of communication of this order, strictly in accordance with law, upon affording an opportunity of hearing to the petitioner. Full stop. Paragraph. Needless to mention that the respondent number 3 shall pass a reasoned order, in case the respondent number 3 finds that the petitioner is not entitled to interest on refund as prayed for by the petitioner. Full stop. Paragraph. It is made clear that this court has not gone into the merits of the petitioner's claim, and all points are left open to be decided by the respondent number 3, in accordance with law.
My lord, I am taking a small leverage, my lord. There are two matters. One is item number 21, writ petition number 27824.
No, my lord.
Another is item number 22, that is writ petition number 27828.
Yes.
Now, what matter is going on? This is for
was
the year
27824 going on. 21 is going on. 22 kadhi. Yes, in the next matter, what is your submission?
And That
In
same
next-
submission, that is for the period 2015.
2008-9.
Same submission, same issue. The
No, the
that-
period is
that
different.
is for the 31/3/2015. Period is different. 31/3/2015.
No. In 27828, the period is 2008-9.
Yes, ma'am. 8-9.
লিখে নিন। এই রিপ্রেজেন্টেশন ডেটটা সেমই থাকছে, আচ্ছা শুধু ইয়ারটা আগেরটা ছিল আপনার, আগের ইয়ার যেখানে ছিল 14-15, এখন সেকেন্ডটাতে ইয়ার হয়ে যাবে 2008-9। 2008-9 এই ডিফারেন্স হচ্ছে। আর পেজেস হচ্ছে অ্যানেক্সার P4 পেজ 27 to 29, আর অ্যানেক্সার P3 হচ্ছে পেজ 23। বাকি সব সেম থাকবে। অ্যানেক্সার P3 হচ্ছে পেজ 23, আর P4 হচ্ছে পেজ 27 to 29, ওখানে 31 to 33 না কিছু হচ্ছে। ঠিক আছে, বাকি সব সেম থাকছে, ইয়ার চেঞ্জ হয়ে যাচ্ছে, ইয়ার 14-15 ছিল, এটা 8-9 হয়ে যাচ্ছে। ঠিক আছে।
My lord, there is a some mistake is, my lord. This petition is for 2015, my lord. If you can come to page 20, page 17, my lord, you will find the period, my lord, and where the demand is.
Sir, your representation shows 8-9. How can you change the period now?
No, the representation is a common representation, my lord. There are
No,
lot
representation
of,
is not common
mane,
representation. In the earlier representation, the period was mentioned as 14-15.
Right, well, right. That may be so, my lord.
Yes, it was mentioned 14-15. Here it is 8-9.
Okay, my lord.
চলো,
Thank you, sir.
disposed of, হ্যাঁ, এটাও disposed of, আগেরটাও disposed of, এটাও disposed of। রাস্তা disposed of
Obliged,
টা
my
করে
lord.
দেবেন, WPS। Yes,
Lordship, item number 8 can be taken.
just a minute, একটু এগিয়ে যান।
And for the petition in 23 and 24, well, it is the matter where the issue was regarding the service of the show-cause notice and the order. That the court has
Yes,
been-
Mr. Not fast. Question of service. He says nothing has been served. Yes, you appeared before them and you sought for time, saying that you want
But in the
documents.
PH case, my lord, the issue is regarding the subsequent order that has been served late, not in 2023. And
Which
the-
subsequent order? I'm
my lord,
unable
the
to get
order
it.
in original was
Huh.
served where they are claiming that they have passed the order in 2023. But we came to know about this order only when there was a recovery notice. My lord, in the first case, there was a show cause notice, which we, as per my instruction, has been
Mr.
received.
Bhattacharya, what is there to show when was he served? Mere saying that you took time on the last occasion on this ground. When was it served? Show me when was it served. That is the only issue. It can be solved immediately. If you show that he has been served, I will. Order in origin, what they have said, I don't understand.
That not be that is in all cases here.
So I'll grant you leave to prefer appeal because they have not been able to show service. Now you are in the know of the order in origin. prefer the appeal before the appellate authority.
My lord, if it court leaves me a grant to prefer an appeal, we will prefer appeal
Prefer
within
appeal,
4
why
weeks.
not?
My lord,
Because you have not been able to show that he has been served. You are only showing it has been dispatched. So he will be entitled to that benefit.
my lord, one more prayer, my lord, they have recovered. They have attached all the Sunday daters and all the bank accounts. My lord, that may be released.
That you go and pray before the appellate authority.
My lord, 7.5%, my lord, it can be released because the business is.
But if you have knowledge of the order in original, why how was it served? No, it was not uploaded on the portal or something.
My lord, it's a service tax. It has to be served by RPAT.
Let me have it on record then I shall pass an order. You file a report.
My lord, humble prayer is the business is stuck for a long time because.
What can be done? You also did not pay attention to, you participated in the proceedings and then you slept. It is.
Prefer an appeal, my lord.
But I have to have something on record that it has not been served. How on the basis of oral saying I will say that no, it has not been served? Show something. You should have brought something. What is that? One thing I am very particular. Because of the business as that I think you should also get stay. Last two lines. But the eligibility was changed for the order issued by the Assistant Commissioner Research Body. The order then dispatched from the auditor as an from available record is observed that the order is not forwarded to this office for the hand delivery. Therefore, the order may be served to the applicant without change. So dispatched from auditor. All that applicant instruction has been given. Whatever report, the report will show to be count formal. But no record, now moving record. And the order is. I can say because he actually at the end. That is evident from the order that he also cannot deny. Order is of 2023. Then he comes to the court. He didn't enter about the he participated in the proceeding.
That all I'm praying is like, let me file an appeal. We will pay the 7.5%. We will file an appeal and let the bank account and the Sunday data be released because the business is.
Really, I will not pass any order. You have to go before the appellate authority. You come so late. You are also indolent.
They have to serve me a copy of the order so that we can.
They have sent is what they can show. Now nothing is sanguine.
Look, as per section 37C of the service of order, it has to be served on the petition or the appellant. That is section 30.
Then let them come with a report. We shall see. Because for that order to be passed, I'll have to have something better than this on record. Who will file? same order, same instruction in that. 25.
Well, I'm for the petitioner, my lord. We are challenging the impugned adjudication order on the three grounds, my lord. First, my lord, there is a violation of principle of natural justice. They have issued the show cause notice without giving me the opportunity of hearing. And it is evident from the show cause notice itself. Second, my lord, the one.
Without personal hearing?
Yes, my lord. Second, my lord, is that one 168A, my lord, the extension of they have invoked 73. They have to pass the order within 3 years. They have by issuing the 168, my lord, knows, my lord has already held in number of cases. My lord passed the interim order. They cannot have, the state has no authority or jurisdiction to extend the time limit by issue of notification. 56 notification number 56 of 2023. Third count that the notices have been issued in the additional notices and portal in the additional notices manner.
What do you want? Should you want it to be stayed or should I set aside and send
Well,
it
and my
back?
lord can decide or state the matter into the adjudication order and
You have a
finally
copy of
decide.
168 judgment, I mean
Yes,
order.
yes, my lord, I have. Here only difficulty is the last portion. I am not.
No, you have better grounds here because it was passed without hearing it, so I'll stay there.
Last portion the there. Yes. Fully petition is going to yes. The number.
When was the adjudication order passed in your
Like
case?
2024, I have explained, my lord, because I did not know, my lord, because of the notices have been issued in the additional portal, my lord. So that is why, my lord.
No, on the tab division bench has held not good service.
Division bench, our high court, my lord also held, my lord.
Not on the portal. On the portal would be good service if it was on the main tab. If it is under the additional notices and orders tab, I will not go and open that. It evades notice. I'll only see the notices and orders. Additional notices and order, a main order is uploaded. How will I know? So division bench has held, no, it's not good service. Because I'll have to go on checking each portal. That is not possible. Otherwise, portal is always good service.
169, my lord, I appeared as a amicus curiae before the Honorable Justice Raja Basu Chaudhary. My lord has already gone through the judgment.
No, but you have to see the practicality of it also. Practicality of it also has to be seen. You cannot.
I just asked questioning myself.
Yes, because in income tax laws also portal is good service, but then that says that along with it has to be an SMS has to be issued. No, so why is it? That is why it shows that merely by putting it up on the portal, a person may not have knowledge of it. Now you are
no,
it's not additional.
Rule 182, section 180.
Followed. So therefore, you have to give it a practical meaning. Law, if you go strictly by the letter such that everything else becomes, then everybody will be prejudiced. That you have to give one meaning which is acceptable. In any case, I will not go into hair splitting because division bench has done that exercise.
My lord also held in case of Birla Brothers.
This writ petition
Not today.
Not today. Why not today?
I was supposed to bring the brief today, but inadvertently I missed it.
Instead of the 26 and 28, so after gonna do it, but other food is that's why 26 and 28.
Very well. Chalo, not today. Chalo, next. Next.
27 is my repetition. But this is with regard to the amount that has been deducted by the authority in view of the fact that I am to file with the section 112 appeal. My 107 was dismissed. Against that, I have to file my 112. Now, the amount has been deducted. At
Yes,
paragraph
Mr.
10, I have stated that I have deposited the 35,000 amount, the 10%. Lordship directed me to produce the challan, my lord. This is it. And my lord, Mr. Chakraborty was supposed to take instructions. Lordship, subject to my lord's convenience, this can be disposed of. And I have also filed the appeal. Appeal to file করেছি because at that point of time when the writ petition was filed, due to the staggering mechanism, the appeal could not be filed. This is the appeal. This has been filed. Yes, 5th, not now. 5th January this has been filed. তাই তো? এটাই তো appeal number. 5th January this has been filed. Yes, yes, because when that point of time, well, that point of time, there was due to the staggering mechanism, I could not file my appeal. That I have stated.
What is the problem? I couldn't understand.
My lord, my 107. হ্যাঁ ঠিক আছে তুমি বলো।
It's a case 107. After 107, there is a period of 3 months for filing an appeal. The tribunal was not formed. They had written to the authorities that I am contemplating filing. In the meantime, before that expiry of period, they had recovered the. Now they have filed an appeal before the tribunal. One of the filing has in tribunal. So now the 10% they have must have deposited.
Before the tribunal.
Yes. Now they have filed before the tribunal and they have deposited must have.
Yes, yes, that is the challenge that I have.
Whatever the recovery is, they should be entitled to get.
Yes.
Whatever.
I'll direct them. You make a representation before them. They will.
Filing has started.
But they have
But-
paid that.
Yes, I have paid that amount.
They will wait.
Will actually pay.
The amount which has been deducted in excess of 20%, that has to be made over to them.
Yes.
So that's what I'm saying. He'll make a representation.
But only thing,
dispose
but
it.
only thing, if a lordship takes a representation, they may once again reject it, and then again I have to
will
come up
they
with it.
reject it? I
Lordship
will
only
reject
consider.
according to- I will
These
say
are the
that.
admitted facts that I've.
No, I as a writ court, I will not direct refund and all. You go approach them. I am giving you liberty.
My ঠিক আছে। But paragraph 15, I have stated that at that point of time, I
Where
could
is
not
your
file my appeal.
instruction, Mr. Chakraborty?
ঠিক আছে, অসুবিধা নেই।
Now the officers are so reluctant to do it.
Why?
I don't know when a thing is coming. WhatsApp. I say it's by a WhatsApp. There is no signature. There's no validity. I say, keep it. They keep it. This I'll bring it, and this consent order should not. Is retiring within 15 days. There is no more. Well, I could get this instruction there. Well, I told him you should have waited for at least 3 months. First place, he should not have taken this. Nowadays, we are coming in the bad books because we are telling the truth to the. We are telling the officers that this should be done this way. Hopefully, I was not audible.
No. This writ petition has been filed Request was there not to take any calls captain.
That's an interim order, yeah.
That is deemed to be interim.
That is an interim order.
Yes, Mr. Lahiri. I'll extend it for a week then.
For a
because Again, tomorrow I'll have to extend again. If
No, for a week.
Week or Malad, in fact, no, it should be 2 weeks.
For 1 week will put everybody on toes. But everybody will at least be here. चलो लिखे नहीं
Yeah, Commissioner. I have indicated to Mr. Bhaskar Banerjee.
So you correct the cost.
To them also. Just to indicate to my lord, it was a mistake. I'm good.
Thank you. Password to different.
One more time, just with certain relevant language of the section. Because my argument would be, the intention of the legislature is a paramount consideration. While considering whether the legislature intended to provide the appellate authority with the power to condone the delay or not. And consequently, the High Court, while considering, because from this, the appellate tribunal has not yet been set up under section 112. So any order passed by the appellate authority, automatically the High Court gets the jurisdiction to consider the propriety of the order. So we'll now kindly take the language of section 107 subsection 1. 4 is of more relevance. One gives any person, provides any person by any decision of the order passed by the state GST or union territory by any adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or the order is communicated. Now, my lord, there is another period prescribed under subsection 2, which your lordship has taken 6 months. Now, my lord, we'll straight away come to subsection 4. The appellate authority may, if he is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 3 months or 6 months, as the case may be, allow it to be presented. My lord, the language is presented within a further period of 1 month. So one of the key words in my respectful submission would be presented and further period of 1 month. Now your lordship will see, apropos this, my lord, there is subsection 6 contemplates that unless there is a pre-deposit, no appeal is entertainable. But however, subsection 4 and subsection 1, if read together, does not expressly exclude. There is no express exclusion of what would happen or in like any other statutes or thereafter within. None of the languages which is used in several other statutes finds place in the at least section 107 of the GST Act, that's 2017 Act. My lord, apropos this section, my lord, kindly first take some other sections where there are mechanisms of appeal provided under the same statute. But when there is a provision for appeal, my lord, the same language is not used. My lord, kindly give me that chart that you had prepared. Where is my chart? No, where is my chart? Lord, you can give it. There's so many charts. Where is my chart? Now, Lord, kindly take section, which is the section you showed. Kindly take first section 100 once. Of the 2017 Act. Appeal to appellate authority. Well, kindly take subsection 2 and the proviso. This is on advance ruling. Every appeal under this section, which is subsection 2, shall be filed within a period of 30 days from the date on which the ruling sought to be appealed against is communicated to the concerned officer, jurisdictional officer, and the applicant, provided that the appellate authority may, if it is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the said period of 30 days, allow it to be presented with a further period. Now, kindly See the difference in the language, not exceeding 30 days. So this is the significant difference, not exceeding, but not thereafter. These are express exclusion, not exceeding. I'll give you, Lordship, we prepared a chart of several special statutes which has similar languages. Shall be entertained, not exceeding. None of the language, my lord, if your Lordship
Mr.
comes.
Hooks,
Yeah.
We can get into all this.
Yes.
The problem is if the Honorable Supreme Court has commented on the language of section 107(4).
Yes.
And has read it in a tone which seems to be mandatory, at least on the surface of
yes.
the order.
Yeah.
Then can we now further interpret we'll have to then say that the expression of the Honorable Supreme Court is not binding, in a sense that it is not a reason at all. If we can say that, then only we have this avenue of going into the sections further. This course of interpretation will be open to us only if we can cross the threshold of the judgment. The judgment is the hurdle.
Well, I'm grateful, my lord. Your Lordship, what fell from your Lordship, it seems. It really is. Well, this is a very, very significant expression that your Lordship has used. Seems. Because it is not clear from the line, from that one line judgment, it is really not clear. But it really seems. Now, my lord, when it seems and it is not clear, would that amount to a judicial precedent within the meaning of 141? Now, my lord, kindly let's have a look at the order of the Supreme Court first, my lord. Give one by one, give. I'll just give you. So I thought we should have made a compilation. First, give the single. Na, debe na. Nebo na. I'll just give it to your Lordship. Kindly bear with us for a moment, my lord.
Yes, I have it. That.
Sorry, my lord. This is the order of 17th of February 2025. Multi-trading. Yes. Delay in refiling the specially petition is condoned. Heard the learned counsel appearing for the petitioner. Now, my lord, the delay is of 3 months, which cannot be condoned in the light of the express provisions of subsection 4 of section 107 of the Jammu and Kashmir Goods and Service Tax Act 2017. If I may just read it once again. The delay is of 3 months, which cannot be condoned in view of the in the light of the express provisions of subsection 4 of 3 of 107. Hence, no case is made out to interfere with the impugned order. Specially petition is dismissed.
So, ergo, a delay of only 1 month is condonable. That is what the Honorable Supreme Court is saying then. And that is what the statute is.
Well, if your Lordship really looks at it,
cannot be condoned.
So, well, then we have to look at, then, my lord, then we have to look at the fact which was there before the Supreme Court. Well, if your Lordship will see, this was the appeal by the dealer. My lord, kindly take the judgment which was assailed before the Supreme Court, the division bench judgment of the Jammu and Kashmir High Court. Where did I read it from? Yes. Well, if your Lordship will see the first paragraph, the issues in these petitions are That is, number one is whether the appellate authority under subsection 4 of 107.
It can be condoned by the appellate authority and whether
Yes.
the High Court can do it under
Right.
226.
No, my lord, competent to condone the delay in filing of appeal against the decision or order passed by the Act and adjudicated beyond.
Yes.
Beyond the period
Beyond
of 1
the
month.
condonable period, whether it can be done by the appellate authority, and if not by the appellate authority, whether by the High Court under 226. These were the questions.
So that means two situations, my lord. If it could not condone, so the appellate authority considers that no, I don't have the power to condone. No appellate tribunal. The dealer comes before the High Court, and that's exactly what happened now. Now, my lord, kindly briefly take the next page. My lord, at the bottom of the first page, kindly take this, my lord. Have already been set at rest in judgment dated 13th of August 2024 in WPC 1413 and clubbed matters, and therefore are no longer res integra, and what has been held in the said judgment would apply to the 4 of the instant petitions. So it just follows. Now, my lord, what has been followed, if your lordship kindly turns to the next page, this is the quoted portion of the judgment in the case of 1413 of 2024, which has been followed here. The appellate authority cannot entertain an appeal under 107 against a decision or order of the adjudicating authority if it is filed beyond the period of 4 months. That is 3+1 from the date of the decision or order is communicated. Then subsection 1 prescribed period of limitation for presenting the appeal for 3 months. However, subsection 4 gives discretion to the appellate authority to condone the delay beyond the period of limitation, provided it is satisfied that the appellant was prevented by sufficient cause from presenting the appeal within the period of 3 months. However, such discretion is confined to condoning the delay to the maximum period of 30 days. And now, my lord, here, my lord, kindly see this, my lord. And not beyond that. My lord, this provision does not say that, because here the language does not say like, but not thereafter. There is no such provision like there is there in section 100, section 107, subsection 4. So now, my lord, here, this is where in our respectful submission, Calcutta High Court Division Bench 4, which we have, we will show it to your lordship, consider is otherwise. So, my lord, none of this, whether the language of the section, how relevant is the language of the section, and what would be the purport of section 29, subsection 2 of the Limitation Act, no consideration. I'll show, but the previous judgment of the JNK indeed did consider. Now, my lord, here your lordship will see it says not beyond that. No such prescription, at least under the statute. By making such provision in subsection 4, the legislature has foreclosed the further discretion of the appellate authority to condone the delay beyond the period of 30 days. The scheme of the Act of 2017, in particular provisions of subsection 4, expressly exclude the applicability. Now, my lord, kindly make a note of this. It records the division bench of the previous division bench or the coordinate bench of Jammu and Kashmir records expressly exclude. With respect, my lord, this is contrary to 3 judgments of the Supreme Court, including Glaxo and what is the other one? Hongo, which says, and the new judgment of Justice Pardiwala, which has come SV Oils, which expressly deals with when in a special statute can you expressly exclude and what is the implication of implied exclusion. These kind of language which says not thereafter, this has been considered to be, if not expressed, at least the intention was to exclude. In 107, there is neither. It just prescribes another period of limitation. The appellate authority has a discretion, if sufficient cause is shown, to condone the delay if it is filed within the subsequent period of 1 month, nothing more than that. In my respectful submission, my lord, the 2017 Act is silent on what would be the situation if it is filed beyond that. So it has to be now judicially interpreted, and now that this interpretation, Justice Oka's judgment come in. Now, my lord, interestingly, my lord, kindly take this at paragraph 2. The petitioners are in all these petitions are dealers. They have assessed. Then, my lord, kindly take para 5. My lord, kindly take para 4 once. In the instant case, the impugned order was passed by the adjudicating authority on 5th December 2023, and the same was communicated to the petitioner. On the same day, the order was communicated to the petitioner on her phone, such and such. However, the appeal was filed on 10th June 2024, after a period of 6 months and 5 days. The petitioner had not filed any separate application for condonation and delay. However, in the memo, petitioner stated the reasons of delay. Then, neither the petitioner has disputed the date of communication of the order. Then, I'm skipping that line, my lord. Now, kindly come to the second line. If such is the reason given by the petitioner to seek condonation of delay for the period beyond 30 days, as prescribed by section 1074, this court cannot, by any stretch of reasoning, bring the case of the petitioner under exceptional circumstances or term it a case of extreme nature to invoke his extraordinary jurisdiction and condone the delay, despite there being statutory prohibition not to do so after a particular period. So the division bench of the Jammu and Kashmir High Court was of the view that if an extraordinary case was made out or a case was made out, then there was the authority and jurisdiction of the High Court under 226 to condone the delay. But in this facts of this case, it did not make out. The petitioner failed to make out such case. Then the petitioner has herself remained negligent and remissness. What is the word? Remiss. In preferring the appeal within time and therefore must suffer its consequence. The assessment order passed by the adjudicating authority under the Act of 2017 cannot be kept open-ended for indefinite period, and the timeline prescribed in the statute are required to be respected and complied with. Now, my lord, then it comes to the other WPs, writ petition. Then, my lord, kindly come. Separate writ petition facts are considered, and the reasons given for the delay in each of the writ petitions are considered. Then, my lord, kindly come to page para 19 of the judgment. Neither the petitioner has disputed the date of communication of the order, nor has he placed on record any material before the appellate authority to demonstrate that during the period of limitation, the petitioner was under such a disability which prevented him from filing the appeal in time. If such is the reason given by the petitioner. So, we are pausing. So, if I can make out a case, so there was a possibility. If such a reason is, my lord, I was here. Yeah, if such a reason given by the petitioner to seek condonation of delay for the period of 30 days as prescribed such and such, this court cannot by any stretch of reasoning bring the case of the petitioner under exceptional circumstances or term it as a case of extreme nature to invoke its extraordinary jurisdiction and condone the delay despite there being statutory prohibition not to do so after a particular period. The petitioner himself remained negligent and remiss in preferring the appeal within the time and such, suffer the consequence, the assessment order, similar, my lord, similar thing. Then, my lord, if your lordship will kindly take, in view of the aforesaid facts, we are of the considered opinion that the case of the petitioner herein also does not fall under exceptional circumstances explained above, which would warrant interference by this court in the exercise of extraordinary jurisdiction. So each case on its merit considered, and the division bench of Jammu and Kashmir High Court came to a specific conclusion that no case had been made out to invoke the extraordinary jurisdiction of the High Court under 226. Now, hypothetically, if any of the petitioner had made out a case, order was not communicated to me, I was on deathbed, XYZ.
Order was not communicated, limitation will not set in. Because then the condonation is immaterial.
My knowledge of the order came in later, or I was communicated at a subsequent stage. Yes. I.
So knowledge, if you
period would not even start.
Even not set in. So,
Yes.
So this provision will not apply.
Yeah. So now, my lord, in some of the WPs, your lordship will see
Where
No.
even after this,
Yeah.
even today, in one of the matters, I said that since
Yes.
order has not been communicated in your matter only,
Yeah.
order was not communicated properly, therefore limitation did not set in.
Did not
Therefore,
set
there was no question of section
Right,
107(4) application. But
Right.
where you are having knowledge of it by any other means, say aliunde, whether then by application of the principles of section 5 that you are prevented by way of sufficient cause. Now there the question will arise, because Mr. Bose, it is one thing to say that I did not have knowledge and limitation did not set in. It is another thing to say that I had knowledge, I was prevented by sufficient cause. Now this prevention by sufficient cause will be reason enough for the appellate authority to condone delay only if the prevention is for a period of 1 month. If it is beyond that period, whether sufficiency of the cause that prevented you would be taken into consideration by the High Court even under Article 226 and would be treated as an exceptional circumstance is a question which we need to answer
No, my lord,
in the light of the judgment.
in light of this judgment. No, according to me, my lord, that has been answered by the Calcutta High Court Division Bench in all four. Now, since we are dealing with Justice Oka's judgment, so
S.K. Chakraborty held the field till such time this was pointed out.
and subsequent to S.K. Chakraborty's one more has come.
Yes, Justice Nagratna.
No. The Division Bench of Calcutta High Court.
Taking into consideration this.
Taking into consideration.
This Oka's judgment.
No,
Justice
not
Oka's
Justice
judgment.
Oka, not Justice Oka's judgment. Not Justice Oka's judgment. No. This was not pointed out, so this possibly wasn't even taken into consideration. No, I am not on that, my lord. Communicated. Post communication, I was prevented by sufficient cause. Well, understanding of Justice Oka's judgment would mean that the sufficiency of reason and the power of the appellate authority to condone is limited to 1 month.
Yes.
If you come 1 day after 1 month, which was the case in that, well, a popular construction arbitration subsection 3 of section 34, bad luck. If you've come
120 days.
Yes, 120 days, 3 months plus 1 month, 1 day, Justice Rumapal held, because Justice Rumapal referred to 29(2) and Justice Rumapal's judgment till holds field, and in all these judgments, that is what is referred. There is an express exclusion within the meaning of subsection 2 of section 29. So 4 to 24 will not apply of the Limitation Act. Because it's a special statute, it's a special period prescribed under the special statute. So, but that prevention of the sufficient, because you're taking away the right of a party to assail an order of adjudication. So, well, it has to be harsh enough. So, well, that language, well, here in my respectful submission, if there is any scope of interpretation, that must be to the benefit of the dealer or the SSE.
Has to be, should be, but then we'll have to hold that section 5 applies as has been held in SK Chakraborty. If it does not apply, then in that case the question of sufficiency
absolutely irrelevant. It becomes irrelevant. No, I'm saying that in order to exclude the applicability of 5, the language has to be, as has been held over the years,
there's no doubt about it.
express. But we are coming back to Justice Oka. Now your lordship will see. So this is the judgment which went before Justice Oka. And apropos this, if your lordship once again takes the trouble of coming back to Justice Oka's judgment. So the delay which was refused to be condoned by the High Court was before the Supreme Court. So there are two ways of looking at it, my lord. One way is the way just your lordship is looking at it. Now, is there a possibility of looking at the same judgment in any other way? In my respectful submission, I say yes. There is, of course, what fell from your lordship that this is, no matter how cryptic or how unreasoned it is, but there is a finding on 104. And it says that there's an express provision that delay, it says the delay of 3 months.
So you mean to say that the delay occasioned by the petitioner in this case was such that it could not have been condoned if
facts of the case. It is a fact of the case. This is not a judicial precedent. It is on that fact of that case and in view of the language, SLP special leave petition was not entered in because this is a special leave petition. This is not statutory right of appeal, unlike under section 61 from IBC, you have a right of appeal.
Discretion.
Yes, discretion. So it says that no, you don't. Now, my lord, apropos this, my lord, I should give your lordship one judgment of the Supreme Court, which says that a judgment without reasons or a finding of in a judgment without any reasons. My
No,
lord,
that's
that,
not binding. That's
no, I'm not binding. I'm saying that that does not have a precedential value.
because no merger happens. It's
My lord, merger, then my lord, we'll go to Kuni Ahmed and Code distillery principle. I am not even the merger principle. Even if this principle of merger is applied here, what merges is that the High Court did not exercise the jurisdiction because on the facts of this case, after considering, High Court held, the division bench held that this does not deserve to be condoned. So rejected. So that same consideration of the discretion of the High Court went up in appeal. Supreme Court said no. So what was being considered by the Supreme Court was not interpretation of 1074, because the High Court had already exercised the jurisdiction that I can condone the delay. I am considering consideration delay. Well, it would have been otherwise if the Jammu and Kashmir High Court had said that I don't have the authority because 107 subsection 4 says that no limitation beyond the period of 1 month is entertainable. I cannot entertain your petition in view of second. On the contrary, the division bench entertained, examined in each case the period of delay, but it held that you were negligent, you were reckless, recalcitrant. Was it condoned in any of the cases? I stand corrected. I am told that in this case of Jammu and Kashmir High Court, 5 writ petitions were considered. In one, apparently, it was condoned. Will lordship, that will be of real. My lord, if you, my lord, kindly take paragraph 9, WP 1562 of 2024. Where is it not condoned? My lord, let us consider, my lord, paragraph 9, 1562, which would be the 3rd page of the J&K judge. In the instant case, the order impugned in the appeal before the appellate authority was passed by the adjudicating on such and such. Under 73, the order was communicated to the petition on the same day. The order was communicated to the petition on telephone. The appeal was preferred on 5th July. After 6 months, there was such a delay of more than 4 months after expiry of the period. It is envisaged under subsection 4 of section 107. There is no separate application filed by the petitioner seeking delay. Then, learned counsel for the petitioner submits that the assessing authority did not take into account the fact that in respect of the financial year 17-18, tax to the tune of such and such had been deducted at source. With respect to the works of construction of model police station such and such, he submits that while passing the assessment order, which was sought to be challenged before the appellate authority, the aforesaid aspect escaped the attention of the assessing authority. Be that as it may, the issue raised cannot be adjudicated upon in these proceedings. However, having regard to the averments made in the petition, we deem it appropriate to permit the petitioner to approach the assessing authority with proof with regard to the payment of goods and service tax deducted at source. Should the petitioner approach the petition authority, the issue shall be re-examined and necessary correction, if any, required in the assessment order shall be made. We make it clear that we do not intend to return any finding on merits, and instead leave it to the assessing authority to revisit the assessment order if the same is required in light of the aforesaid facts brought to the notice of the assessing authority and project to a down payment of such and such. So one writ petition was entertained at least. The Miller, kindly take the next one, 1443. Miller, here the last sentence of para 12, the delay, the reason for the delay has been quoted. Then if your lordship turns to the next page, that is the reason which has been quoted from the appeal petition. Because my mother was suffering in a crucial disease, dementia, and during her follow-up treatment of the disease, I could not reply file the appeal, or I could not file the appeal. Counsel for the petitioner submits, the assessing author did not take into account the fact that in respect of financial such and such, escape the attention of the assessor author. Done, my lord, kindly take para 14. Be that as it may, the issue raised cannot be adjudicated upon in this proceeding. However, having regard to the averments made in the petition, we deem it appropriate to permit the petitioner to approach the assessing authority with proof with regard to payment of goods and services tax deducted at source. Should the petitioner approach the authority concerned, the issue shall be re-examined and necessary correction, if any, required in the assessment order shall be made. We make it clear that we do not intend to return any finding on merits and instead leave it to the assessing authority to revisit the order of assessment if the same is required in light of the opposite fact brought to the rule and projected double payment of GST. So in given cases entertained. So now, my lord, if I may just trouble your lordship once with, my lord, we have prepared. My lord, allow me to first do this and then give your lordship a chart which we prepared in other special statutes where the language is different and how Supreme Court deals with that. Then, my lord, kindly take first the judgment which says that if there is a judgment of the Supreme Court on a particular issue without reasons, but what would be the case? This is.
Would you say that this is without reason?
Well, I would say that this is a finding on the facts of that case. This is not an interpretation of 1074. Here we are before your lordship that whether
there are two things which are apparent, Mr. Bose. One is that the Honorable Supreme Court has read the express provisions of subsection 4 of section 107 in a certain way.
Yes.
Would you say that is not reason at all?
I would say, my lord,
may not be elaborate, but it's reason indeed.
No, my lord, this is not a reason sufficient to become a judicial precedent for the purpose of interpretation of a statute.
What is the sequitur for this?
Sequitur would be, my lord, consideration of the intention of the legislature, other provisions of the Act, the Limitation Act.
Show me that.
Yes. My lord, this is a judgment which we are showing. Well, this is State of Uttar Pradesh versus synthetic chemicals. Well, this is reported in. Give me the citation. 1991 post Supreme Court cases, page 139. My lord, if your lordship can straight away come to para 39.
Yes.
But the problem has arisen due to the conclusion in the case of synthetic and chemicals, well, which is the KB judgment. The question was if the state legislature could levy vend fee or excise duty on industrial alcohol. The bench answered the question in the negative, as industrial alcohol being unfit for human consumption. The state legislation was incompetent to levy any duty of excise either under NT 51 or entry 8 of list 2 of the 7th schedule. While doing so, the bench recorded the conclusion extracted earlier. It was not preceded by any decision. Discussion, I stand corrected. So similarly, in our case, my lord, no reason or rationale could be found in the order. This gives rise to an important question if the conclusion is law declared under Article 141 of the Constitution, or it is per inquirium and is liable to be ignored. Then, my lord, inquiria literally means is there. My lord, now kindly come to para 41. Does this principle extend and apply to a conclusion of law which was neither raised nor proceeded by any consideration? My lord, pausing here for a moment. My lord, with respect, my lord, this was not even under consideration before the Supreme Court. Whether the appellate authority has the power, Limitation Act, Section 5, does it stand expressly excluded? No discussion, no argument, nothing. What was under consideration was that division bench said, you have not made out a case for condonation of delay. This wasn't even under consideration. But why? Well, what possibly the only rationale we can see is that a period was sought to be condoned in a SLP before the Supreme Court. Supreme Court says that, listen, if 1074 restricts itself to 1 month, where's the question of condoning it for 3 months? So this cannot be said to be an interpretation of the section to exclude the applicability of the Limitation Act. So that would be, my lord, that would be like reading into the judgment which does not provide. My lord, apropos this, my lord, kindly take the next sentence. In other words, can such conclusions be considered as declaration of law? So this is what the Supreme Court poses a question to itself. Then is the answer. Here again, the English courts and jurists have carved out an exception to the rule of precedence. It has been explained as rule of sub silentio. A decision passes sub silentio in the technical sense that has come to be attached to that phrase when the particular point of law involved in the decisions is not perceived by the court or present in its mind. But again, pausing here for a moment. Limitation Act, exclusion, 29(2), whether the language of this expressly, nothing was in the mind, could not have been in the mind of the Supreme Court because it wasn't even there. Then my lord, Summoned on Jurisprudence is referred, 12th edition. Then Lancaster Motor. Then in Lancaster Motor, the court did not feel bound by earlier decisions as it was rendered without any argument, without reference to the crucial words of the rule, and without any citation of authority. It was approved by this court in Municipal Corporation versus Gurnam Court. The bench held that precedents sub silentio and without argument are of no moment. The courts thus have taken recourse to this principle for relieving from injustice perpetrated by unjust precedents. A decision which is not express and is not founded on reasons, nor it proceeds on consideration of issue, cannot be deemed to be a law declared to have a binding effect as is contemplated under Article 141. Uniformity and consistency are core of judicial discipline. But that which escapes in the judgment without any occasion is not ratio decidendi. And then Sharma Rao is quoted, my lord. Sharma Rao is that judgment in the case of 67 Supreme Court. It was observed. It is trite to say that a decision is binding not because of its conclusions, but in regard to its ratio and the principles laid down therein. Any declaration or conclusion arrived without application of mind or preceded without any reason cannot be deemed to be a declaration of law or authority of a general nature binding as a precedent. Restraint in dissenting or overruling is for sake of stability and uniformity, but rigidity beyond reasonable limits is inimical to the growth of law. But applying the principles of this judgment to the judgment of Justice Oka, the first thing that my respectful submission would be, it was on the facts of that case. Supreme Court wasn't even considering the issue of whether 1074 would exclude the power of the appellate authority to condone the delay beyond the period of 1 month, which is subsection 4. Or whether it would have, or if there is any express exclusion, or whether there is an implied exclusion within the meaning of 29(2). Because when you're looking at a special statute, it has to, 29(2) has to be taken into consideration. Otherwise, why would any court or how would any court interpret that? No, there is no authority of the appellate tribunal, or so to say the High Court, sitting or considering a judgment in view of the, I mean, since the appellate tribunal has not been constituted, would have the power or not. So, my lord, there has to be a consideration. There is none. There is absolutely nothing. My lord, on the contrary, my lord, on the point of express exclusion, my lord, the judgment of Division Bench of Justice Devanshu Boshak is under challenge. The operation of the judgment is stayed. Possibly that is the judgment where Supreme Court will finally lay down 107. We are expecting that. We are hoping for that. So if it does, that would be a consideration. Possibly, again, we hope that it will not be a one-liner like Justice Oka's judgment. Because since notice has been issued, so since notice has been issued, so we are expecting that a judgment is there or would come. Well, till such time that such a judgment or the law on 1074 is not pronounced, in my respectful submission, as the law stands today, there is no the provision does not expressly exclude the applicability of the Limitation Act in view of the language. Now, my lord, we've prepared a chart. Just have a look at this chart, my lord, of several special statute, including the GST Act itself. My lord, I showed your lordship section 100 once. My lord, kindly have a look at the other section once. I showed your lordship section 100, which says not exceeding. Now, my lord, kindly once take, before your lordship takes this chart, kindly take one section 101B. So, my lord, there is one more judgment of the Supreme Court. If in the same statute, different languages are used, then the legislature was, the intention of the legislature was expressly to exclude what was not excluded in the other provisions. So they all have to be taken into consideration and read together. I hope and trust that whoever will do the S.K. Chakraborty appeal before the Supreme Court brings to the knowledge of the Supreme Court these provisions. Well, kindly take 101B once, the second proviso of 101B of the GST, the 2017 Act.
Yes.
I had referred 100. Now kindly take 101B, second proviso. Your lordship will find again that not exceeding 30 days is there. The second proviso of subsection 2 of section 101B.
Not exceeding.
Not exceeding. Conspicuously missing in 107. Same provision for appeal before the appellate authority. Another appellate authority considering appeal from another situation. Not exceeding, incorporated expressly. 107 does not say that. Leaves it open-ended. So then, my lord, the judgments come in. Now, my lord, kindly have a look at this chart that we've made over to your lordship. My lord. First is section 34, of course, of the Arbitration Act. Kindly, my lord, see. We've just given those, just the relevant portion just for your lordship's consideration and the relevant judgments which considers this. Kindly take the proviso.
Yes, not thereafter.
Not thereafter. Then, my lord, kindly take section 74.
Not exceeding 60 days.
Not exceeding 60 days. Then, my lord, kindly take serial number 4. Kindly take serial number 4, section 125 of the Electricity Act. Expert sitting here, Electricity Act expert. Kindly take that, not exceeding 60 days. Then, my lord, kindly take Rule 17 of the Central Administrative Tribunal Procedure Rules. Negative, see the language negative, couched in a negative form, shall, for review, shall be entertained unless it is filed within 30 days. No such language is incorporated under 107. Similarly, if your lordship will also now kindly turn to Serial number 7. Here, take this.
Yes.
Section 20 is there. Not there. And your lordship is aware DRT has the power to condone open-ended, not expressly excluded. Then, my lord, kindly take serial number 7. Companies Act 421 appeals. Towards the bottom of that page, subsection 3 has been quoted. It says, but within a further period, not exceeding 45 days. Again, my lord, kindly take section 13(2)(a) of the Consumer Protection Act, not exceeding 15 days. No, so, my lord, so there is a, now, my lord, apropos this, my lord, express exclusion. Since Hongo has been referred in the new judgment, so I'm not troubling your lordship with Hongo because the relevant paragraphs of Hongo has been considered in the new judgment. Well, this would be the judgment in the case of that SV Global. Batch of petitions, my lord. The judgment of Justice Sundaresh. I will kindly first take paragraph 3. This would be internal page 33 or 136. Towards the bottom, your lordship will file the page numbers. Wait a minute. So, your lordship got that, my lord?
Para 3.
3. Yes. This will give your lordship an insight into what was the issue before the Supreme Court. We are dealing with a batch of matters wherein the high courts, whether the impugned judgments have dismissed the first appeals filed by the appellant under section 74 of the Right to Fair Compensation and Transparency Act as been barred by limitation. Then, my lord, para 4. The primary issue before us is on the interplay of section 74 read with section 103 of the 2013 Act on one hand, and, my lord, kindly make a note of this, section 5 and section 29(2) of the Limitation Act on the other. This is what needs to be considered while interpreting 107. And I'm sure if, my lord, our court has interpreted, we have got 4 in our court, which has all interpreted that there is no express exclusion. Now, there can only be a Supreme Court which says otherwise. Till such time comes, my lord, I am sure, my respectful submission, what has been interpreted in situations of interpretation of this clauses of this nature would apply. And of course, the division bench, what has been held will, of course, definitely apply to our courts. And, interestingly, your lordship will find no coordinate division bench has held otherwise. My lord, time kindly come to para 59. My lord, everything is quoted, sections, provisions.
Para 59.
59, my lord, this would be at page 99.
Yes, yes. This 75 of the
Page. Why are they different?
Much has been said.
Actually, my lord, I am reading from the INSC, which is the official website of the Supreme Court. They have given your lordship the do you have a INSC copy?
Para 59 begins with much has been said.
Much has been said.
He
Much
has
has
para 59 here.
Oh, 59 there as well. Very well. So I'll refer to only the paragraphs then. Much has been said and argued on this provision. Now this would be 29.2. The provision throws light on the interplay between the 63 Act and special or local laws. It comes into play when the period of limitation is prescribed by a special or a local law. This provision applies to a suit, an appeal, or an application. This part of this provision speaks of the application of Section 3, over which there is no quibble. It gives due recognition to the period of limitation provided under special or local law. Then, my lord. Then after it considers, my lord, the next sentence, however, for determination of the period of limitation, Section 4 to 24 pertaining to extension and exclusion shall apply. Thus, Section 29.2 is the provision which triggers the activation of Section 4 to 24. This applies ordinary to every special or local law unless such law contains an express exclusion of the 63 Act. To put it differently, the intention to exclude 4 to 24 of the 63 Act has to be clear, apparent, and manifest. All three are conspicuously lacking in subsection 4 of Section 107. Therefore, the language of Section 29.2 indicates the intention of the legislature to extend the application of Section 4 to 24 to all special or local laws. A specific exclusion alone would take away its application. The application of 4 to 24 can be excluded by such laws either individually or in totality. The provisions pertaining to the exclusion of time can also be applied at different stages. Suffice it to state that Section 4 to 24 will not apply only when their exclusion is expressly provided by such special statute or local law. In other words, there is a debarment of the exercise of any implied exclusion as a matter of rule. Mr. Lordship, got that line? Well, after this 2025 judgment and the law express, well, we are hopeful that the interpretation finally would be in favor of 107, that it does not expressly exclude. This is, well, I stand corrected, not 25. This is February 2026 judgment, what your Lordship is reading and considering. Then, my lord, kindly take that same paragraph. In other words, I read out then. However, it can be done by the court only in exceptional situations, and that too when the person claiming so discharges the burden of proving the same through the scheme of the legislation. Mere incorporation of a specific period of limitation under the special law does not amount to express exclusion of the 63 Act. Rather, it must indicate that sections 4 to 24 of the 63 Act are excluded. As a matter of rule, the said words must be present in the special or local law. Otherwise, it would amount to nullifying Section 29.2 of the 63 Act. Then, my lord, it continues. 29.2, the ouster, the historical background of 29.2, how it has been applied over the period of time. My lord, I would have wanted to show some more paragraphs if you look.
5 more minutes.
Yes. Or I can come back on any other day convenient to your Lordship.
Up to you. Entirely up to you.
Any day convenient to your Lordship. I will take some more time, my lord, so that then I'll be able to complete my argument. I shouldn't take more than 15 to 20 minutes more.
We'll have it on Monday then.
Very well.
Didi, Monday 2 PM কিছু আছে? 2 PM রেখে। Monday 2 p.m.
No, well, on Monday I'm traveling.
Difficult.
So if it could be, my lord,
Tuesday, Wednesday, we have already fixed matters.
oh, very well.
Thursday, Fridays, I won't take this. We will go in March. March is only 1 week in between.
So we can come back. Very well. The week after the holy
Yes,
weekend.
9th.
Holy, very well, 9th.
9th or 10th, whatever.
9th, 2 p.m.
9 तारीख 9 तारीख 2 p.m. হবে
9th at 2 p.m. Subject to your lordship's convenience.
হবে
Obliged, man. Obliged.
লিখে নিন Third, Mr. Bose, learned advocate appearing for the petitioner. Full stop. He has begun $29.
Like 29, Mr. Churaria is kindly keep it tomorrow.
Not today. Not today. What is this matter?
Lord, this is pertaining to a search and seizure.
ঠিক আছে, থাক, 20. Not today. Next.
It takes some time. We're challenging the possible sanction order under section 279. On many grounds, one is that we have filed a reply in response to the show cause notice. We have filed a reply on 29th of April 2025. They have not considered my reply in this first ground. Now we have to show the provision.
You're
of the law.
challenging what, 148 AD? I mean, 148 notice?
No, this is a sanction order. 279(1).
Sanction for prosecution?
Sanction for prosecution. Tomorrow I come back and may I come back tomorrow morning? Lordship?
Tomorrow, not today.
31 is also the same. Because there is a delay in depositing the TDS only. So 1 to 12 months, this is the only, where we have deposited the tax along with the interest, we have to deposit it. This is the only ground, madam. There is a judgment of other high court also.
It is a settled by our division bench.
Very well. কালকে
Great.
ছেড়ে দিন, কেউ নেই 3টে বাজে।
May I be permitted to mention one matter, my lord? The 6 writ petitions, your lordship on 2nd February, your lordship has passed an analogous order. In such order, my lord, your lordship has give us the liberty to file a supplementary affidavit. My lord, in that supplementary affidavit, we will annex a order in original from sister, which I got on yesterday, my lord. So your lordship has given 1 week time to file.
You
I'm
file it.
praying for
Whenever
leave
it
to
comes, you
extend.
file it. You keep it ready. Whenever it comes, you file it. Yes.
But one I am for the respondent.
I am for the petitioner, my lord. The extension of interim order expiring on
Affidavit in opposition is ready, Mr. Bhomik.
Yes, ma'am. Then will I, but the transfer did not. I find original opposition is.
You are filing it today?
Yes, I find. Then will I will give the copy.
But you file it today, then if you are filing.
Yes, ma'am. Yes, ma'am, I am fine.
लिखें देखिए एकটু দেখান তো Any. This matter, Didi, लिखे नहीं. This matter is appearing under the heading extension of interim order. Upon being mentioned, therefore, এই হেডিংটা 1 থেকে 5 এর সবকটাতেই থাকবে যতগুলো এক্সটেনশন আছে ফুল স্টপ extension of interim order for extension of interim order. Upon being mentioned, therefore, FOR, full stop. Paragraph. Mr. Bhomik, learned advocate appearing for the respondent revenue authorities, filed affidavit in opposition to the writ petition on behalf of the respondents. Full stop. The same is taken on record. Copy thereof shall be served upon the learned advocate appearing for the petitioner. Full stop. Learned, the petitioner shall be at liberty to file affidavit in reply thereto, comma, if any, comma, within 2 weeks from receipt thereof, full stop. The subsisting interim order shall continue till the end of April, comma, 2026. List this matter for hearing in the in the month of March 2026. Good. Give your names. Yes. One, no, two. একই ম্যাটার নয় তো ইয়েতে বেঞ্চে মিস্টেক
from the respondent, Milord. But this is similar, these matters similar 2 to 5, Milord, all related similar. The order passed by the Milord, the jurisdiction assessing officer, not by the faceless assessing authority, Milord. That Milord, we are not completed the affidavits. And your lordship knows also from Milord, the April 2026 Milord laws also being going to be changed. But in some matters, Milord, we have filed the opposition because the point is, Milord, the law point. Milord, the affidavit cannot improve. Milord, some matters we have filed affidavit, and each and every matter filing of affidavit, Milord, uses of Milord,
not required.
paper are not required.
So I'm extending the interim order.
Yes.
লিখে নিন এই প্রথম লাইনটা সেম থাকবে এই 2 to 5 2 to 5 same order.
Yes, Milord.
Heard learned advocates appearing for the respective parties. So extension of time to file affidavit I am not doing.
That is not, kindly give that.
Full stop. As prayed for by Mr. Bhattacharji, comma, learned advocate appearing for the respondents. Let affidavit in opposition to the writ petition be filed within 3 weeks from date, full stop, affidavit in reply thereto, comma, if any, be filed within 2 weeks thereafter, full stop. The subsisting interim order shall continue till the end of April 2026 or until further orders, whichever is earlier. আগেরটাও এটা
অন করে দিন।
Yes. দেখি বাকিগুলো দিয়ে দিই। হ্যাঁ, অর্ডারগুলো সেপারেট। Mr. Bhattacharya, you had completed, isn't it?
Yes, yes. I reply to his submission, Mr. Parsi's reply.
Yes, Mr. Pardiman.
May it please, my lords, I had also completed my rejoinder. I had just said I'll point out two things. One is my learned friend had relied upon a decision in the case of Agilent in support of his contention that the ATG deduction is not allowable. Now, there are two orders in the case of Agilent for the subsequent assessment years where the tribunal has allowed the deduction. My lords, those orders, my lords, if my learned friend will tender them, my lords, are for assessment year 2021 and 18-19.
Now, my lord, in that score, my lord, I have only, my lord, one submission.
Just let me complete. Yes, Pardiman.
Well, if my lord will see the 18-19 order, just see paragraph 9 at page 7.
Paragraph 9.
Right, my lords.
Paragraph 9.
At page 7.
Yes.
Next, with regard to the corporate tax adjustment, has your honor got that? Has my lord got that?
Yes.
The SSC has raised the following grounds. And then para 8, as with regard to the rejecting of deduction claim under ATG, the AR submitted the appellant as part of its CSR, contributed so-and-so and disallowed the same in the computation of income under section 37. Further, to arrive at the net taxable income, the appellant claimed Indian rupees so-and-so pertaining to the above contribution as a deduction under ATG. AO disallowed the claim for deduction. And then, if they see in paragraph 10, they say in regard to ground number 3, with its subgrounds, we find that this issue has been extensively dealt with by a coordinate bench in ITA number so-and-so Interglobe Technology Quotient Limited, Private Limited, where one of us was a member. Then they've extracted from that order and allowed the deduction. And the argument about there being not voluntary, just see para 7.5 of Interglobe at page 12. As with regard to the reasoning that CSR expenditure are not voluntary but mandatory in nature due to penal consequences, we are of the considered view that the voluntary nature of a donation is by nature of the fact that it is not the basis of any reciprocal promise of the donee. The CSR expenditure are also without any reciprocal commitment from a beneficiary being philanthropic in nature. The Act permits deduction of donations as per ATG, even though the SSE is not getting any benefit out of any reciprocity from the donee. Similar is in the case of CSR expenditure. Thus, the reasoning of the Learned Tax Authority that CSR expenditure is mandatory does not justify disallowance of this expenditure under ATG. And then the tribunal follows that order, my lords. And for the subsequent year, that is assessment year 2021, similar view has been taken by the tribunal in a subsequent order. Para 8 at page 6.
Page 6.
Page 6, para 8.
Para 8.
Learned authorized representative regarding ground of appeal number 4, qua rejecting deduction of rupees so-and-so claimed under ATG in the return, submitted that the learned AO erred in appreciating that the appellate tribunal in the SSC's own case for 1819 and for order passed in the appellant's own case. And then they in para 10, they follow that earlier order. So in the subsequent orders, they have taken a view again different from what was taken in the earlier orders. And you know, there are several other decisions of the tribunal which have considered the first order and distinguished them. I'll just point out one of them in Sikka. Just see Sikka Pots, which is reported in 173taxman.com, page 366. Just see para 2 of this order first, Your Honor.
Yes.
The facts pertaining to assessment year 2021 are that the SSC had filed a return of income for assessment year 2021 on so-and-so declaring a total income of so-and-so under the normal provision of the Act and so-and-so under 115 JB. Case was selected for scrutiny, statutory notice was issued. The SSC had claimed deduction under ATG in the tune of rupees so-and-so towards donations made to Reliance Foundation and rupees so-and-so to Shyam Kothari Foundation for rupees so-and-so. The assessing officer disallowed the claim made by the SSC for the reason that the CSR spending of the SSC is to comply with the provisions of 135 of the Act, which mandates CSR spending, and therefore the same cannot be treated as a voluntary donation eligible for deduction under ATG. Then CIT appeal allowed it. Now we'll see the department's arguments in para 3. If you see the last 3 lines of para 3, the DR in this regard placed reliance on the decision of the Delhi bench of the tribunal in the case of Agilent Technologies, where it has been held that no deduction under ATG is allowable on the amount incurred for the purposes of CSR. Then the tribunal's conclusion starts from paragraph 5. They refer to the judgment of the Supreme Court, which was relied upon in Agilent in the case of PVG Raju in para 6. And then please see para 7. Therefore, to examine if CSR spending of the SSE would be a donation, it is essential to examine whether the donations given by the SSE to Reliance and Shyam Kothari without any material return and without any consideration, and whether it was a grant for quid pro quo, It is not the case of the revenue that the SSC had made a contribution to these institutions with an intention to get something in return. The only contention of the revenue is that the contributions are made as part of a mandate and not voluntary. However, the Supreme Court in the above case has laid down the basic principle that a payment made without any material return and without any consideration and not for quid pro quo is a donation. Therefore, in our considered view, the payments made, whether voluntarily or as part of a mandate, does not negate the intention of the contribution made. The reliance placed by the DR on the decision in the case of Agilent is factually distinguishable. The DRP whose order was upheld in the said case had placed reliance on a decision of the High Court in the case of Hindustan Door Oliver, where the payment made was held as not a donation, since it was found that the intention behind making the donation was to get reserved seats in a college run by the institute to whom the payments are made as part of CSR funding. As already mentioned, the revenue is not contending that the SSC in the present case has made payments to get some material in return. So, otherwise, as I say, if today every donation I get a tax advantage, that you'll say is a return that you're getting for the donation, then ATG becomes a dead letter. So he could never have formed a basis that income has escaped assessment. What is the information in his possession is that for a CSR funding, you have claimed an ATG deduction. Does that suggest that income has escaped assessment? Is the short point which my lords has to consider.
Yes.
And of course, there is FAUJA also, but that is now it is a temporary this thing, so I'm not going to labor that point much.
We are at the interim stage and
only one submission, your lordship. Kindly remember when the first occasion matter was placed before your lordship, that your lordship was, if I am not incorrect, was of the view that when the matter was decided in favor of the SSC by the ITAT, then what is the point to reopening the same? But I believe subject to lordship correction, even if single, I have pointed out one judgment of the tribunal saying that
the judgment of the tribunal in the SSC's own case by a tribunal having jurisdiction over the assessing officer here will be more binding on the assessing officer.
Yes.
So that issue is still in my mind and I'm still of that view only. The view has not changed because of the judgment that you have
No, I try to point out that the point has not been settled.
It has been settled in the subsequent ITAT judgments. You see that they have dealt with exactly the same point that was
no High Court tested the judgment of the tribunals. And our High Court, at least our High Court will test the judgment of the tribunal because we are going to file the appeal. It will be filed within few days.
Supply
in that score, your lordship kindly consider the matter.
Very well.
And we got only one submission of the and last in paragraph number 7, what my learned senior pointed out, it has stated, had already mentioned the revenue is not containing
which one?
The judgment last Shika Port Terminals Limited.
Yes.
As already mentioned, the revenue is not contending that the SSC in the present case has made payment to get something material in return. It has to be dealt with each and every case by the assessing officer making the inquiry.
Very well. In this case also that is the case. In this case also the assessing officer has not at the threshold pointed out that there is something in return.
That is the only reopening stage.
That is important then at the reopening stage also. Because
in all these judgments,
if everything is to be kept for the time of assessment, then everything will be reopened.
Respect to submission, in all these judgments, the SSC has gone through a process. Assessment order pass, CIT appeals, thereafter ITAT. It cannot be said in the threshold the assessing officer.
Similar process was undergone by the SSC in the SSC's own case before the tribunal in this case also. which has not been adhered to by the assessing officer. This is some kind of judicial indiscipline, which at least I will not permit. This is judicial indiscipline. This tomorrow he will say that High Court, I will prefer appeal before the division bench, therefore I am not binding.
No,
That
that
how
is
it
not,
to be dealt with.
that contention was that, my lord, the
I am aware about res judicata not applicable, but I am also aware of rule of consistency being applicable. So he should follow that. This will be anarchy everywhere. It will be absolute anarchy. I will not follow. Somebody has said that because I have a different view. You were open to challenge it. Why did you not carry it up in appeal? You will not prefer appeal at the time when it is right for you to prefer appeal. You will allow the appellate order to attain finality, and then you will take a diametrically opposite view, saying that no, I have a different view and I will stick to it. That should
no,
not
lord,
be
we are
permitted.
going to file the appeal. My lord, we are on a, in few days, my lord, we will file the appeal.
To file, then we shall see.
Very well. लिखे नहीं दीदी this writ petition has been filed against an order dated June 28, 2025, passed under section 148 capital A within bracket 3 of the Income Tax Act 1961, and the consequential notice issued on the same date under section 148 of the said Act of 1961 in respect of assessment year
1920.
Where do I get that?
First paragraph, my lord.
No, of the, where is the notice? Order impugn?
Notice.
My lords, it's assessment year 1920, my lords.
Assessment year 1920. 2019-20. Full stop. Paragraph. What were the two issues on the basis of which the proceedings were sought to be reopened?
My lords, that you, my lord, will find at page 488.
488.
Volume 5, my lord.
Proceedings for reassessment of the petitioner's income for the assessment year 2019-20 have been were sought to be reopened on two grounds, namely inadmissible claim of expense alleging that the claims pertain to capital loss and not revenue loss, and two, inadmissible claim of deduction alleging that CSR expenditure could not be claimed as a deduction under section 80G of the said Act of 1961. That's it.
That's right.
Right. Paragraph. Upon a notice under section 140 paragraph B, upon a notice under section 148 capital A within bracket 1 of the said Act of 1961 being issued, comma, the petitioner furnished a reply whereupon The first ground pertaining to inadmissible claim of expense was dropped by the revenue authorities. However, the revenue persisted with the second ground, and a reopening notice under section 148 of the said Act of 1961 was issued. Assailing the same, the assessee has approached this court by way of the instant writ petition. Full stop. Paragraph. Mr. Pardiwala, learned senior advocate, appearing for the petitioner, submits that the order impugned under section 148 capital A within bracket 3 of the said Act of 1961 has failed to appreciate that a deduction can be claimed under section 80G of 80G of the said Act, G capital, of the said Act of 1961, even if the same is disallowable under section 37 of the said Act of 1961. Full stop. He submitted that the parameters for allowing deduction under the said two provisions were absolutely different. Full stop. It was further pointed out that in the assessee's own case, a similar deduction had been allowed in respect of assessment year 2020-21 by the Income Tax Appellate Tribunal, and despite such fact having been brought to the notice of the assessing officer, the assessing to the notice of the assessing officer, the assessing officer chose to take a divergent view. Full stop. Paragraph. Mr. Pardiwala relied on a judgment of a coordinate bench of this court in the case of Sunil Kumar Ganguly versus Income Tax Officer, reported at 2010 322 ITR, 2010 322 ITR 297. In support of his contention that orders of tribunal as well as commissioner appeals, commissioner within bracket appeals, passed in favor of the assessees would bind the assessing officer if the same had attained finality. Full stop. Paragraph. It was submitted that in the case at hand, the order passed by the tribunal in the assessee's own case for the assessment year 2020-21 had not been carried in appeal by the revenue. Full stop. Paragraph. relying on a judgment of the Honorable High Court of Bombay in the case of Lupin Limited, Lupin, Lupin Limited versus Deputy Commissioner of Income Tax, reported at 2025 172 taxman.com 158 Bombay, comma. It was submitted that the statements and objects accompanying the Finance Bill 2014, by which amendments had been introduced into the said Act of 1961, whereby deductions on CSR expenditure were prohibited, did not suggest that did suggest that CSR expenditure of the nature described in sections 30 to 36 of the said Act of 1961, expenditure of the nature described in sections 30 to 36 of the said Act of 1961 would also be allowed as deductions under those sections, subject to fulfillment of conditions specified therein. Full stop. Paragraph. আচ্ছা, এই যেখানে উপরে লুপিন ল্যাবরেটরিজ জাজমেন্টটা লিখেছে না, লুপিনের ওখানে একটা আরো লিখে দিন, হি না লুপিন তো হয়ে গেছে, লুপিন ল্যাবরেটরি তো হয়ে গেছে, এটা আর একটা জাজমেন্ট রেফার করলাম এখন, বম্বে হাইকোর্টের আগে ক্যালকাটা হাইকোর্টের একটা রেফার করেছি, দেখুন। হ্যাঁ লুপিন চলছে, সরি, হ্যাঁ সুনীল কুমার গাঙ্গুলি, হ্যাঁ সুনীল কুমার গাঙ্গুলির সঙ্গে এটাও লিখে দিন, ওখানে লিখে দিন, ওখানে he further buttressed his contention that in the hierarchical adjudicatory system, comma, a lower authority is always supposed to abide by the directions and decisions taken by the higher authorities, comma. He cited a division bench judgment of the Honorable High Court of Bombay in the case of Bank of Baroda versus H.C. Srivastava, reported at 2022 122 taxman 330 within brackets Bombay. Full stop. ওখানেই লিখবেন, for the same proposition another judgment of the Honorable Bombay High Court in the case of Karanja, Karanja, Karanja Terminal and Logistic Private Limited versus Principal Commissioner of Income Tax and others, reported at 2022 325 CTR within bracket BOM 392 was pressed into service. Full stop. Paragraph. Mr. Padiwala, in a nutshell, your opening submissions are all right?
Yes, my lord.
Yes. Paragraph. Mr. Bhattacharjee, learned advocate appearing for the respondent revenue authorities, comma. Vehemently contended that this court should not intervene in the matter at the stage of issuance of a notice under section 148 of the said Act of 1961 in exercise of its jurisdiction under Article 226 of the Constitution of India. Full stop. Paragraph. It was submitted that although the tribunal had taken a view favorable to the assessee in the assessee's own case, favorable to the assessee in the assessee's own case, in respect of a matter pertaining to assessment year 2021, comma, the assessing officer was well within its rights to take a contrary view in respect of a matter pertaining to a different assessment year. Full stop. Paragraph. He invited the attention of this court to the Finance Bill of 2014, Finance Bill of 2014, and submitted that the object thereof was to curtail the benefit of deduction on expenses in respect of corporate social responsibility. Full stop. Paragraph. Relying on a judgment, আচ্ছা যেখানে 226 লিখেছেন না, should not jurisdiction 226 ওখানে একটু লিখে দিন। In support of his such contention, he relied on two coordinate bench decisions of this court in the case of Messrs. Britannia Industries Limited versus Union of India, within brackets WPA 24534 of 2024, and Debraj Dealers Private Limited versus Union of India and others, within brackets WPO 3359 of 2022. 2022. Full stop. Paragraph.
My lord, only my submission to the bill, finance bill, was that more the objective of CSR to share the burden of government in providing social services by companies having net worth or turnover profit have a threshold if such expenses are allowed as a deduction, it would result in subsidizing the
So
around
that was your submission, that to curtail deductions.
Yes.
That is what I have recorded.
Yes.
To curtail deductions, so that you don't avail of deduction on expenses on corporate social responsibility. Because if I start paraphrasing, I will go on dictating for 2 hours. Don't expect, that will be too much expectation of court. Because as it is, I'm at the interim stage, merely
Yes,
because
yes,
you wanted to cite these many judgments, I have to spend this much of hour. That's unfair also, but it can't be helped. Because at the interim stage, you know what is going to happen. Unnecessary. Chalo. हाँ, देवराज हाँ. Relying on a judgment of the Honorable Supreme Court in the case of the Commissioner of Expenditure Tax, Andhra Pradesh versus Shri PVG Raju, reported at (1976) 1 SCC 241, Mr. Bhattacharya submitted that, Bhattacharya submitted that a donation by description would mean something for which the person donating does not expect anything in return, and something which has been done voluntarily. Full stop. He thought to demonstrate that expenditure for the purpose of sharing the burden of government was not voluntary, and as such, the same could not be described as expenditure. Full stop. Paragraph. He next relied on a judgment of in the case of Nazir Ahmed, NAZIR, Nazir Ahmed, AHMAD, versus the King Emperor, reported at ILR LX3, LXIII 372. To contend that where power is given to do a certain thing in a certain way, it must be done in that way or not at all. Full stop. For the same proposition, he also cited a judgment of the Honorable Supreme Court in the case of Ram Deen, D-E-E-N, Ram Deen Maurya, M-A-U-R-Y-A, within bracket DR, versus State of Uttar Pradesh and others, reported at 2009, 6 SCC 735, full stop, paragraph. Seven three five, full stop. উডিবান লেখা আছে তো। In support of his contention that the court should not interfere at the reopening stages, comma, he relied on a judgment of the Honorable Supreme Court in the case of Raymond Woolen Mills Limited versus Income Tax Officer, reported at 1999 236 ITR 34, full stop, paragraph. For the same proposition, comma, he also relied on a judgment of the Honorable Allahabad High Court in the case of Smart Vishwas, VISH, Smart Vishwas Society versus Assistant Commissioner of Income Tax, reported at 2023 156taxman.com 188, full stop, paragraph. Mr. Bhattacharjee next cited a judgment of the Income Tax Appellate Tribunal, Delhi Bench, in the case of Agilent, AGILENT, Agilent Technologies, within brackets, International Private Limited versus ACIT stroke NFAC, Delhi, reported at 2024 160taxman.com 238, within bracket, Delhi-TRIB, Tribunal Trib, bracket close, to submit that upon taking into consideration the judgment of the Honorable Supreme Court in the case of PVG Raju, within bracket Supra, as well as the finance bill of 2014, comma, the tribunal had come to the conclusion that deduction claimed by the assessee in respect of CSR expenses could not be allowed under Section 80G of the said Act of 1961. Full stop. Paragraph. It was further submitted that the respondent revenue authorities are preparing to prefer an appeal against the order passed by the tribunal in respect of the assessee's own case pertaining to assessment year 2020-21. Full stop. Mr. Padiwala, comma, learned senior advocate appearing for the petitioner, rejoined by submitting that a reading of the finance bill, comma, 2024 would not indicate that CSR expenses which could otherwise be allowed as deduction under section 80G were prohibited from the zone of deduction. Now prohibited, now excluded from the zone of deduction by the Finance Bill of 2014, full stop. He further submitted that in the case of Agilent Technologies itself, pertaining to different years, the tribunal has held in favor of the SSE and allowed deduction of expenses under section 80G of the said Act of 1961, notwithstanding the earlier judgment of the tribunal against the SSE. Full stop. In support of his contention, he has cited two orders of the tribunal dated March 26, 2025, passed in respect of assessment year 2018-19. Passed in ITA 1171 stroke Delhi DEL stroke 2022, তারপরে in respect of and order dated September 17, 2025, passed in ITA 3684 stroke Delhi DEL stroke 2024, pertaining to assessment year 2020-21. Full stop. Paragraph. He also relied on another judgment of the Mumbai Tribunal in the case of ACIT versus SICA, SIKKA, SICA Ports and Terminals Limited, reported at 2025 173 taxman.com 366 within brackets Mumbai Tribunal, to drive home the point that deductions on account of CSR expenses are being permitted under section 80G of the said Act of 1961. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. Paragraph. It is not in dispute that in the SSE's own case, the relevant tribunal has allowed a similar deduction claimed by the SSE in respect of assessment year 2020-21, and such order passed by the tribunal has not yet been carried in appeal by the revenue. Full stop. In such view of the matter, in the prima facie view of the court, it was not open for the assessing officer to take a diametrically opposite view, even if the matter that had fallen for consideration before the assessing officer pertained to a different assessment year. Full stop. Although this court is cognizant of the fact that the principle of res judicata is not applicable to proceedings under the said Act of 1961, if the same pertain to two different years, comma, yet the rule of consistency would certainly apply, full stop. In the order passed, order impugned passed under section 148 capital A within bracket 3 of the said Act of 1961, comma, there is precious little to decipher as to how has the assessing officer held that the facts of the assessee's case in the present year differed from those in the assessment year 2020-21 for the rule of consistency to not apply. Full stop. Paragraph. Insofar as the assessing officer's reasoning as regards not allowing the CSR expenses to be deducted under section 80G is concerned, comma, the same also, comma, again prima facie appears to be a product of misreading and misinterpretation of the objectives of the Finance Bill of 2014. Full stop. In such context, comma, the judgment of the Honorable Bombay High Court in the case of Lupin Limited Supra clearly supports the assessee. Petitioner, assessee na karo, petitioner. Petitioner. Full stop. Paragraph. This court is also of the prima facie view that merely because an expense cannot be allowed to be deducted under section 37 of the said Act of 1961, comma, the same ipso facto would not mean disallowance under section 80G also if the same is otherwise allowable. Full stop. Paragraph. As regards the contention of Mr. Bhattacharya that writ court should not intervene, comma, firstly, the proceeding that has been impugned in the present writ petition is one against which there is no other statutory remedy available to the assessee, to the petitioner. And secondly, the issue raised by the petitioner is jurisdictional in nature. Full stop. It has been well settled by the Honorable Supreme Court in the case of Gene Nit, eta ami apnake ye diye debo citation, that a writ petition can be maintained even against a reopening of assessment proceedings if the same is done arbitrarily. Full stop. The case at hand prima facie betrays arbitrariness. Full stop. Insofar as the judgment in the case of PVG Raju is concerned, comma, the same in the prima facie view of this court cannot assist the revenue in as much as there is nothing on record, at least at present, to presume that the assessee, i.e. the petitioner, did not donate voluntarily, and there is certainly nothing on record to show that there was a quid pro quo, QUID PRO for the donation given by the petitioner. Full stop. Paragraph. In such regard, comma, the reasoning given by the Mumbai Tribunal in the case of Sikka Ports and Terminals Limited Supra appears to be apt, APT apt. Insofar as the judgments in the case of Nazir Ahmad and Ramdeen Maurya are concerned, there can the propositions laid down by the said judgments are salutary, but the same hardly apply to the petitioner's case, except the fact that the assessing officer ought to have followed it. It was for the assessing officer to do it in the manner ordained by the tribunal, by whose order it is bound, rather than to take a diametrically opposite view. Full stop. Paragraph. The orders of the coordinate benches in the case of Britannia Industries Supra and Debraj Dealers Private Limited Supra were rendered in the peculiar facts of this case, where arbitrariness was not apparent. Full stop. Paragraph. Smart Vishwas Society also turned on its own facts. Full stop. In Raymond Woolen Mills Limited Supra, comma, the Honorable Supreme Court was convinced that there was prima facie some material on the basis of which department could reopen the case. In the case at hand, comma, the prima facie view is just the opposite. Full stop. For all the reasons aforesaid, comma, this court is of the view, comma, again prima facie, that the petitioner has a strong arguable case. Full stop. Accordingly, comma, there shall be an interim order in terms of prayer E of the writ petition. Full stop. the respondents shall stand restrained from proceeding further in terms of the reopening notice dated June 8, 2025, issued under Section 148 of the said Act of 1961 till further orders, full stop. The paragraph, as requested by Mr. Bhattacharjee, affidavit in opposition to the writ petition may be filed within
8 weeks.
8 weeks from date, full stop.
4 weeks.
Affidavit in reply thereto, if any, be filed within 4 weeks thereafter. List this matter for hearing immediately after expiry of the time fixed for exchange of affidavits. I will do certain corrections in the order because lot of it has gone in flow.
No, just one date is 28th June, not 8th June.
28th
June, he said.
28th June.
28th, that's all.
28th June.
Obliged, my lords.
Deep look. Thank you.
Deeply obliged.
আমি দিয়ে লিখে দেবো। Next.
Okay. Item 7, they have provided a supplementary affidavit with regard to the delay. Let me take instructions on that. Instead of next week.
Supplementary affidavit filed on behalf of the petitioner is taken on record. Full stop. Copy thereof has already been served upon Mr. Banerjee.
The order is in post 2023. The petition has challenged the part in the circumstance on the ground the state was privilege law. This best of the state has already filed a modified return of 2020 as a care for and which according to the study has not been other things to a petitioner that the modified return instead of making the demand appears to the recording of the order 12 that the modified return is going to the back of assistant to or no point. Now, in zero critical error, there is a lapse and lapses of the part of the responsibility concerning keeping the appropriate by the not returning question resignation. One in the criminal return. It's not justified. Next one, in the same manner, nothing is a page 10 last one. Other considering the fact that the of the case officer of the area of the view, the issue involved cannot be adjudicated. The receipt of evidence by the particular I am also of the view. It should have been able to solve the private case for improved order that got protection of the action. Now, what is that? The initial education is not very the respondent of the contact consider as process the modified question, claim of the one in question, and giving the penalty of the teacher no confidence. What is of the included party? Now, my lord, they have not supposed to now let's come. The time has lapsed. Now can come to page 7. This is time to start. Now we can see. Well, it is 28 like the underlying. Then we brought to the root of system of system. Then whenever I see nuances regarding education, various technical were processing the data, file electronically for reproduction. The time period for processing data is that. Let us be at your 12 Therefore, these results of this and the matter being considered by the board and decided to reflect the time frame prescribed secondly by the substance. To the exercise of powers as well, the board hereby directs the returns of income, filed my returns are also have been erroneously invalidated by CBI. Shall now be processed. The intimation of the old person is one of the actions. This is the binding of the income tax officer. And the pursuance of this can come. The settled account as yet in the authority. And with the request to possible. Now, also can you come? Page 14. Yes, wait a minute. Page 14. The pursuant to this section of I personally appear before the on page 1225 as his office in connection with the reading by visit the state authority for me that state authority 1340 it is pending before the Honorable High Court of Calcutta. Therefore, the concerned authority cannot interfere with the proceeding further in the matter of process said detail as per civil circular. The said authority further said no action or decision can take place are clear appropriate orders are passed by the Honorable pending before. This is his opinion, madam. No, page 6. Order be passed directly.
Yes, Mr. Sharma, why pendency of the writ petition, why will they not, because that liberty was granted?
Yes,
This was not required, no mandatory order was required, why?
no mandatory record, but yes, my lord is correct.
The order itself made it clear that they will be free to do it.
There is no need for this notification.
Yes.
It is also not applicable in my opinion. Because this is in with respect to erroneous invalidation. with the returns which are erroneously invalidated by the CPC. I don't know whether this
Yes,
is
very well.
but
uh,
they
I will
member
also
should
not,
have proceed.
I will also not pass any mandatory direction, but I'll clarify that mere pendency of of this writ petition should not restrain the authority from considering it if it is otherwise considerable. In
Fine.
terms of this notification, if he falls under it, he will consider. If he doesn't fall, he will give reasons, whatever. But this cannot be a reason that merely because writ is pending, so what? Writ has itself, the order itself had given you liberty. No, why? There was no reason. The order at page 11 says that it will not prevent.
Yes. The only thing, my uncle will also directly reported for himself.
Direct in accordance with law, they'll do it, because I also don't know the case of why they have not been processing it. What is the reason, whether it falls under it. I will clarify that the pendency of the writ petition, it should not have deterred them, and it will not deter them, because there is an order passed by this court itself.
Yes.
That
By
this
giving
will not.
reference to this order date, order 13th of December 2020.
Yeah, okay. But they have not. And the only thing, madam, when they will process, they will give an opportunity to the.
Why have you not processed? Can you take instructions? Because you inform them, then it can be sorted out here and now. Because this order doesn't show that there is any hindrance. There is no impediment on his part to take instructions and come back. When do you want to come back?
And day after tomorrow.
পিটিশনের পেজ 110টা দেখো
Lordship can be in this culture, what they do. Can be because
100?
110.
বলা আছে কেন করতে পারছে না because nobody is taking responsibility. ওটার বেসিসে
110?
Yes.
Yes.
This is the reason why we are possible.
Take instructions, Mr. I'll just clarify again and ask you to take instructions.
I'm later, Mr.
Mr. Dutt. GA2 of 2026 has been filed seeking an order directing the respondent revenue authorities to process the modified rate
of various snacks and that it triumphs, and it they have treated it as namkeen, and they classified it on heading 2106-9099 in the residuary. That focus from 2017-18 they have classified that. In the for the period 2017-18 to 19-20, the department has conducted an audit. They have checked my records, the returns, everything, but they have not raised any dispute. Subsequently, by another audit, they have contended that I have misclassified the classification of these goods on the basis of certain circulars. So my humble submission is that the department is all along know that I am manufacturer of these namkeens, which is I classified in 2106, and they have tried to classify it in the 1905. Now this dispute is pan-India dispute. In other high courts, the honorable high courts are pleased to grant stay of this kind of sugar. So may I first invite your lordships the show cause notice is at page 1. Thank you. Page 123.
Yes, I'm at page 123.
My lord?
I'm at page 123 only.
That point 2.1. The on scrutiny of statutory returns and financial records, it revealed that during the period 2020-21 to 22-23, the said taxpayer was supplied various extruded snacks and fried extruded pellet snacks items to such and such company under the various brand names by classifying them under HSN code 2106-9099 and paying tax at the rate of 12%. Then they have extracted the name. Now, kindly however, during visit of the premises, it observed that the said taxpayer is manufacturing as well as procuring unfried snacks, pellets manufactured, processed through extrusion and expansion from different suppliers. The said procured or manufactured unfried snacks and pellets are fried in vegetable oil and with flavored substance packed and supplied in ready to eat under different brands. It appears that the final product manufactured involving the above process should have been classified under HSN code number 19059030 and would have been taxable 18% GST under Schedule 3 of the notification number 1 of 2017. Thereafter, my lord, at page 124, that it appears that they have issued the show cause notice and the audit objection on the basis of this circular. The circular number 189012030. It is hereby clarified that the snack pellets such as prams, which are manufactured through the process of extrusion, are appropriately classified under tariff item 19059030, which covers goods with description extruded or expanded product, savory or salted, and thereby attract GST at the rate of 18%. While serial number 16 of Schedule 3 of notification number 1 of 2007. On the basis of this circular, my lord, they have issued this show cause notice. There is no proposal to revert the said show cause notice, and they straightway demanded the tax. Now, my humble submission is that the classification I have treated, that is more specific, and it should not be brushed aside by issuing that circular. And there are certain, and in case of classification dispute, my lord, there is no ingredient of any suppression of facts or mistake. If that is not satisfied in the show
No,
cause notice,
they have invoked section 74.
yes,
Not only on the ground of suppression, I mean, not on the ground of suppression, they have gone by the definition. If you see page 130.
Yes.
Page 130, paragraph 4.3. See the definition first, page 130 top. Failure to furnish any information on being asked for in writing by the proper officer. This is one of the ingredients of suppression. 4.3 explains how you fall within it.
my
So you go and answer the show cause.
Well,
You
my
show
humble
cause and get
submission
it
is,
quashed.
my
I mean,
lord,
get it dropped.
my humble submission is that when they have came to my factory and they have checked all the documents, and on that they have access. I will show your lordship. Kindly see the one show cause notice they have
Very well.
issued for the
We'll meet on the next day. Today you will not be able to complete.
Well,
When can we come?
tomorrow.
Third, Mr. Bhaumik, learned advocate. Thank you.